ಸರ್ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
Hello, sir. Not right.
Fresh matter for 230 minutes. House. Fresh matter for 230. Houses are being demolished. Houses are being demolished. My sites are formed in survey number 19/4. But the writ petition was filed. There is encroachment in survey number 1. So, and this was directed conducting of survey. There is no such survey that is conducted. So, proceedings are initiated that my land falls within survey number 1.
Yes.
Serial number 23, I pay for 1 week time.
Is the other side here?
The other state, Your Honor.
Only state.
Yes, Your Honor.
Only state.
No, Your Honor.
Then 23.
23, Your Honor. State, Your Honor.
It's coming up for preliminary hearing. 2018 matter.
You have not complied with office objections.
Let
us see.
We already complained, Your Honor.
No, let us see.
1 week time may be given. Please, Your Honor.
Matters come up for preliminary hearing for non-compliance of office objection. Yes.
Till number 46, my lord. My lord, to recollect in the last hearing date, Chandrasekhar had argued, my lord, for some time. Date accommodation, my lord. But we have informed, my lord, he's on.
Who's on the other side?
My lord, we have informed him on through phone call, my lord.
But I'm appearing. Sorry, SM Chandrasekhar is appearing for the.
For the petitioner, my lord. I am the petitioner.
Where is the respondent, sir?
We have informed him.
No informed. No informed.
We will see. If when the matter reaches, you can mention. Yes. Yes.
Between that, my lord, the records are not available in the office. Records are not available in the office.
Tahsildar has granted land in favor of the petitioner in the year 1972. Mutation entry has been made. Name of petitioner was found in both column number 9 and 12 up to 2000.
Computerized Kwani was introduced by the government. My lord. Subsequently, the entry was not made.
Yes.
In the office, my lord. Special to representation to the president. Stating that, my lord, records are not available.
Where is the endorsement?
Next year, my lord. 2013-14.
Annexure A.
So, please.
No, annexure A is not an endorsement. Handwritten, what is this?
That is endorsement. This is hard. Endorsement.
No, no.
What is page number?
ಏನ್ರಿ ಇದು? This is the original, sir.
ಸೀಲು ಇಲ್ಲ ತಹಶೀಲ್ದಾರ್ ಸೀಲು ಕಾಂತ
ಕೆಳಗಡೆ ಇದೆ ಕುಡಿದು.
ಅದೇ ಅದೇ ಇದೆ ನನ್ನ ಹತ್ರ ಸೇಮ್ ಇದೆ ರೌಂಡ್ ಸೀಲ್ ಅಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ದು ಏನು ಇಲ್ಲ
It appears this is the original. See? Usually it is not given like this.
ಅದು ಕೊಡೋದಲ್ಲ ಆಮೇಲೆ ರೌಂಡ್ ಸೀಲ್ ಒಂದಿರುತ್ತೆ ಲೆಟರ್ ಹೆಡ್ ಇರುತ್ತೆ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಬಟ್ ಹಿಸ್ ಕೇಸ್ ಇಸ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ he says that there is no records available in the office hence computerized RTC cannot be done. He has given representation at annexure B, my lord, requesting that. He has produced annexure F onwards, my lords. RTCs, handwritten RTCs and ಹೇಳ್ತಾರೆ ಅವರು. Based on the
ಇದು
correct. ಇದು ಮಾಡೋದು para 3 on hearing the learned constable petition and AG and on proceedings of the papers, this court find that the Tahsildar is duty bound to consider the application filed by the who claim to acquire right over the purchase of registered instrument. This registered place the grant and the duty of the Tahsildar to secure the original grant registers have issued registered contemporaneous records and so and the petition. After providing a partial petition, look into the original records and yes. Because instead of the sale deed place the original grant. Therefore, the sale deed and based on the grant and grant is annexure C. Dated.
So same as WP number 41438 of 2017, dated 24th of February 2022. But one day on sentence ಬರ್ಕೊಳ್ಳಿ. There was a sale deed. In this case, there is no sale deed.
It is a grant. Alleged grant.
ಅಂದ್ರೆ ಅವನು there is a subsequent purchaser.
Yes.
ಅದನ್ನ ಬರ್ಕೊಳ್ಳಿ, ನಾನು ಕರೆಕ್ಷನ್ ಮಾಡಿ.
Number 2.
That a grantee of 2 acres 20 guntals of land in survey number. That a grant was made in favor of petitioner on 86. That the respondent number 4. That respondent number 5 here in Gadrappa. That he claims that he is the grantee of to a 1 acre 30 guntals of land in the very same survey number. As per order dated 24/2/2004. This grant is subsequent. My grant is of the year 1980. He filed application before the regularization committee. That order, I have challenged before the AC. The AC, by his order dated 17.
ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡಿದಾರ?
ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರಿಗೂ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ ಯಾವಾಗ?
2006 ಅಲ್ಲಿ. 2006 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Where is that?
AC set aside that order. And again I filed appeal to the DC. DC reverse that. Against that I filed a writ petition before this honorable court. This honorable court will actually kindly see
56, next year G.
Annexure G. But by its order dated, as per Annexure G, operating portion page 60 last 5-6 lines. There is no material to hold that. That is black. Page 60. Bottom in the
Yes.
there is no
Para 9.
material to hold that. 1 acre 30 acres of land claimed by the third respondent was out of the land granted in favor of or that it overlapped with the land granted to the father of the petitioner. Suspect is the material aspect which the revenue authorities ought to have decided. The assistant commissioner has also not recorded any specific findings in this regard. Therefore, the right course is to set aside the order passed by the assistant commissioner and deputy commissioner and is remanded to the remand ಮಾಡಿದಾದ್ಮೇಲೆ assistant commissioner ಹೇಳಿದ
Further, my lord's finding, it will not be open for the revenue authorities to find out the
It will be open.
It will be open. Sorry, it will be open. Correctness of the claim made by the petitioner.
Correct. So what happened?
The assistant commissioner again made order in my favor of holding inquiry and held that the grant made in my favor is genuine and the order because which is made earlier to in the year 1986 in my favor, it is a subsequent order that has been made. For that reason, the order has been set aside. Against that, he filed an appeal before the deputy commissioner. And in the meanwhile, there was a direction to the Tahsildar to conduct a spot inspection and to fix the boundaries of my land. And thereafter, Tahsildar conducted survey measurements and spot inspection. And there, it was found that I have possession of the land and you draw merger also. Thereafter, he filed an appeal for revision petition before the deputy commissioner. The deputy commissioner, by his order dated, annexure came, this is the impute order. There, the deputy commissioner says that because ಮೂಲ ಮಂಜೂರಾತಿ ದಾಖಲೆ ಎಲ್ಲ ತಹಸೀಲ್ದಾರ್ ಹತ್ರ ಇರೋದ್ರಿಂದ ಇದನ್ನ ಮತ್ತೆ ಅಲ್ಲಿಗೆ ರಿಮಾಂಡ್ ಮಾಡಿ.
ಏನಕ್ಕೆ?
This order I have read page 80 page 80. ಆದೇಶಿಸ ಮೇಲೆ 3 ಲೈನ್ ನೋಡಿ. ಮೂಲ ಮಂಜೂರಾತಿ ಕಣಗಳು ನಿರ್ವಹಣೆ ತಹಸೀಲ್ದಾರ್ ಅವರ ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದರಿಂದ ಮೂರನೇ ಎದುರುದಾರರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಬಗ್ಗೆ ನೈಜತೆಯನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಸೂಕ್ತ ಕ್ರಮ ವಹಿಸಲು ತಹಸೀಲ್ದಾರ್ ಶ್ರೀನಿವಾಸಪುರ ತಾಲೂಕಿನವರಿಗೆ ನಿರ್ದೇಶಿಸಿದೆ. ಆದ್ದರಿಂದ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ರಿಮಾಂಡೆಡ್. This order I have. He also observed that there is an order in my favor and that there is an order subsequent to that in favor of the fifth respondent. This order is read without application of mine. Parties from the beginning, 1986 to till this day, it stands in my name. I have produced annexure. Annexure C12. Till this day, parties are stands in my name.
Kindly see.
could not have sent the matter to the Tahsildar.
That was para 9 of the earlier order of this court.
Hmm.
While setting aside the order. That's my kindly
So there was no dispute that,
whether overlapping is there or not,
Correct.
that factual
so
melts.
therefore, there was no dispute that there were two grants.
Yes,
Now, what he is trying to say is to find out whether the grant made in his favor was genuine or not.
that was
That
also.
that
Melts-
cannot happen.
No, that also melts is the subject matter. It is not that his grant is also in clouds. It is not that melts. There is no such a clear melts. Whether his grant is also genuine or not is one of the melts issue, which the
That
court
was,
has directed.
that was never disputed.
No, court has melts. It will open melts earlier order of this court. With para 9.
Hmm.
I'll read melts. In light of the respective contentions and findings recorded by the authority. Para 9 melts.
Yes, yes.
What emerged is that the Deputy Commissioner has not considered the effect of the judgment and decree passed in OS 95 of 2003.
What is that judgment?
It is in suit for injunction, I think, because they have filed.
That has got the civil court anyway could not have decided
Yes.
regarding the genuinity of the grant.
Grant because they will not, they will
So
only
you-
relating
In
position.
order
Right.
of injunction,
Yes,
even if there is a decree,
yes.
that
Further-
will not,
Yes. As well as
Yes.
further, friend, as the Deputy Commissioner was of the view that the Assistant Commissioner has not recorded any specific finding by perusing the records regarding the disputed question as to whether an extent of 1 acre 30 guntas of the land claimed by petitioner overlap with the lands over which the petitioner claimed the right. Deputy Commissioner ought to have set aside the order of the Assistant Commissioner, remanded the matter by fresh consideration by him. The Deputy Commissioner, without even referring to the effect of the judgment and decree passed in so and so, has allowed the appeal. There is no material to hold that 1 acre 30 guntas of land claimed by respondent was out of the land granted in favor of the petitioner's father, or that it overlaps with the lands granted to the father of the petitioner. This aspect is a material aspect which revenue authorities ought to have
Anyway,
decided.
therefore, there was no doubt.
Further, fellows, further. Next,
it will
next
be open.
it will open for the revenue authorities to find out the genuineness and correctness of the claim made by the petitioner and also the respondent, including that, fellows, it is kept open. Now, fellows, it is Tahsildar who is the custodian of the grant records for that reason, and survey is required.
ಈಗ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅದ್ರ ಬಗ್ಗೆ?
Page 65.
Exercise ಮಾಡಿಲ್ಲ ಅವ್ರು ಯಾರು. Overlapping or not, nobody has said.
ವಾಟರ್ಮೆಲನ್ ಮೇಲಿನ ಆಕ್ಷೇಪಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರು ಹಾಜರುಪಡಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಫ್ರಾಡ್ಲೆಂಟ್ ಎಂದು ಹೇಳಲು ಸಾಧ್ಯವಿಲ್ಲ. ಪ್ರತಿವಾದಿಗಳಿಗೆ ಚಂದಿಗಾನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 10ರಲ್ಲಿ
Where are you reading?
ಪೇಜ್ 65 ವಾಟರ್ಮೆಲನ್.
ಹಾ.
ಮೇಲಿನ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರು ಹಾಜರುಪಡಿಸಿರುವ ದಾಖಲೆಗಳು ಫ್ರಾಡ್ಲೆಂಟ್ ಎಂದು ಹೇಳಲು ಸಾಧ್ಯವಿಲ್ಲ.
ಹೆಂಗೆ? How?
ಪ್ರತಿವಾದಿಗಳಿಗೆ
No. How does he say it cannot be said as fraudulent?
ಮೇಲೆ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ.
ಏನು ರೆಕಾರ್ಡ್ಸ್ ತರಿಸಿದ್ದಾರೆ? Whether original records were summoned? Please show that.
ಉಭಯತ್ರರು ಮೇಲಿನ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಸ್.
Yes.
ಉಭಯತ್ರರು ಹಾಜರುಪಡಿಸಿದ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಗೂ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮಂಡಿಸಿದ ವಾದ ವಿವಾದಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ತದನಂತರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕೆಳಕಂಡ ಅಂಶಗಳನ್ನು ಗಮನಿಸಿದೆ.
So where is the original record summoned? ಎಷ್ಟ್ ಸರಿ ಹೇಳ್ಬೇಕ್ರಿ ಇವ್ರಿಗೆ ಏನ್ ಅರ್ಥನೇ ಆಗೋದಿಲ್ವಾ? ಎಷ್ಟ್ ಸರಿ ರಿಮಾಂಡ್ ಮಾಡ್ಬೇಕು ಮ್ಯಾಟ್ರ್?
Only two they are required. One, original verification of original grants and overlapping.
And other than that, they will do everything else. I can't understand what is their difficulty. The deputy commissioner also has done the same thing now. He now refers the matter to the Tahsildar.
Because he is the custodian of the record and survey is required.
So therefore, the matter cannot be decided by the Tahsildar.
He has to summon the records to his office. He can't send the matter to the Tahsildar and say, you please find out and then give me a report. Hangagadilla. Learned AGA takes notice for response number 1 to 4. Issue emergent notice to respond number 5, returnable by 28th of September 2022. Next para. Learned counsel for the petitioner submits that on an earlier occasion, when the petitioner was before this court in WP number 7665 of 2010, this court by order dated 6th of January 2012 remanded the matter back to the assistant commissioner with specific direction for fresh consideration, keeping in mind the observations made in the order. It was directed that it will be open for the revenue authorities to find out about the genuineness and correctness of the claim made by the rival parties. It was also directed that the authority was required to find out whether the grants made in favor of the rival parties were overlapping. On remand, the assistant commissioner held that when once the land was granted in favor of the petitioner way back in the year 1986, the same could not have been granted to the fifth respondent herein subsequently. However, the deputy commissioner is of the opinion that since the original records are in the office of the Tahsildar, it is for the Tahsildar to verify the records and decide the matter. So saying, the deputy commissioner has set aside the order of the assistant commissioner and forwarded the matter to the Tahsildar. Remand agalla.
Correct.
Full stop. Learned Council submits that the Tahsildar is not the authority to decide this appeal, the original appeal filed under section 49. It is for the assistant commissioner and the appellate authority deputy commissioner to decide the list. Full stop. Consequently, there shall be an ad interim order of stay of the impugned order dated 30/3/2022 passed by the deputy commissioner. Come on till the next date of here. Not necessary.
Ashildar passes an order. That order is in annexure A. I have no grievance. Annexure A minutes. I am the petitioner minutes is the owner of adjacent property survey number 69 of Lakshmi Devapura of Dodballapur Taluk minutes. Tubagere Hubli. The property minutes is section survey number 69.
What is this official memorandum issued by the Tahsildar?
Tahsildar passes an order minutes to remove the encroachment which is caused to the road, which is called as Oni minutes. That road is that was passed on certain earlier occasions also minutes the private respondents have undertaken that will have grown the ragi crop on this property. Some time is required. On 2-3 occasions, minutes Tahsildar did not execute this order. The last order was passed minutes annexure A, page number 14, 26/4/2022. This order minutes, after passing this order minutes, no action is being taken, and the time and minutes in the last 2 years, the proceedings is going on. Kindly turn to page 43 minutes, the sketch showing the encroachment. Page number 15 minutes, the last portion. Tahsildar passes an order categorically regarding removal of warning. There is road, madam. ನಮ್ಮ ಹೊಲಕ್ಕೆ ಸಾರ್ಸಕ್ಕಾಗಲ್ಲ, ಗೊಬ್ಬರ ಇತ್ಯಾದಿ ಕೃಷಿ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ. ನಮ್ಮ ತನದ ಒಂದು 8 ರೈತರಿಗೆ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ, ಅವ್ರು ಯಾರು ಮುಂದೆ ಬರ್ತಾ ಇದೆ. Kindly come to page 43.
Learned AGA takes notice for response number 1 to 5. Issue emergent notice to response number 6 to 8. Returnable by 28th of September 2022. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned AGA. A previous matter Langipari. Copy to be served. Next para. Learned AGA is required to secure instructions from the Tahsildar, Dodballapur Taluk as to why no further action is taken pursuant to the impugned, pursuant to the official memorandum dated 26/4/2022 at Annexure A issued by the Tahsildar. Yes.
Against the order dated 8/6/22 passed by the Deputy Commissioner to vacate the interim order granted on 27/4/2022. What happened? The petitioner and the respondent number 8 and 9 are the absolute owner of the property bearing civil number 110 measuring 3 acres 5 guntahs. Kind of the annexure B at page number 17. Their grandfather, Rachaya, name shown civil number 110. Annexure C, records of rights. The undisputed facts, the petitioners and the respondent number 9 and 10 are the applicant property. After death of my father, the Tahsildar Soti Kata Namit transfer model as per Annexure H. As per Annexure H. And thereafter, some instigation of the some villagers, Annexure G is the page number 31. The Kata has been transferred in our name. Petitioners as well as respondent number 9 and 10 in respect of very property. Subsequent to what happened, the few villagers and one resident of Madheshwara temple, though it is not registered.
M. Mahadevappa and another. Basuraju, Mahadevappa and the respondent number 9 and 10. You were the respondent. You were the respondents in Annexure H.
Annexure H. Responding to Annexure
The
H.
appeal was filed by
villager.
Rajappa and others.
Rajappa, who claims to be a president of Madheshwara temple committee. And another one MP Krishnappa is the secretary. And M. Mahadevappa with Madhegowda, Devana, they are the same villager. Their instigation, they have filed this regular appeal. And in the regular appeal, they handle
with what prayer?
Prayer to set aside the Annexure G.
Mutation entry. In IHC 9 of 2014-15.
As per Annexure G and mutation, they are cancel Madi and Keliku, the honorable the Deputy Commissioner wrongly cancelled my entry. And against that order, the petitioner have filed revision petition before the Deputy Commissioner, Annexure J. And Deputy Commissioner on 27/4/2012 has passed granted an interim order to stay the annexure. Annexure L is the Annexure L page number 53. ಮಧ್ಯಂತರ ಆದೇಶ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರ ಪರ ವಕೀಲರು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ 1964 ಕಲಂ 136 3ರ ಅಡಿಯಲ್ಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಉಳಿದವರ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋ ರಂದು ನಡೆದ ವಿಚಾರಣೆಯಲ್ಲಿ ಪಕ್ಷಕಾರರ ಪರ ವಕೀಲರು ಮಂಡಿಸಿದ ವಾದ ಪರಿಗಣಿಸಿ ಪ್ರಶ್ನಿಸಿದ ವಿಧಾನ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡುವಂತೆ ಆದೇಶಿಸಿದೆ. ಆಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ವಾಟ್ ಹ್ಯಾಪನ್, the Deputy Commissioner by order dated 8/6/2012 with
So, considering our objection and our document, and wrongly shown that we have not provided any document, and cancel the death status quo. As per Annex 59, page number 59 is the order dated 8/22. The typed copy. Typed copy 52 only. 8/6. Advocate for R2 to R6 present filed memo for cancellation of status quo direction. Apply number 1 present. R2 to R6 submitted RTC showing government and that it is an MLAL ADP work going on and hence should not be stopped seeking cancellation of status quo direction. Appellant not produce any document to back its claim. Hence status quo direction is cancelled. Kala 9/2022. So the response, the MLA was very big. The government has not acquired the land in the manner known to law, and no award has been passed and no notice has been issued. The land has not been acquired. Now land and acquire ಮಾಡಿದೆ. They wanted to put up some water tank ಮತ್ತೆ ಏನೋ ಮಾಡಬೇಕು ಅಂತ ಹೊರಡ್ತಾ ಇದ್ದಾರೆ.
Sir, AG
Para 11 of the AC order.
takes notice for response number 1 to 4. Issue emergent notice to response number 5 to 10. Returnable by 28th of September. Next para.
Government quarters offices ಎಲ್ಲ ಬಂದಿದೆ. Belatedly they have gone ಅಂತ ಹೇಳ್ತಾರೆ. But how they have title and whether state has acquired, we need to ascertain. In Eastern Commissioner's order, clearly para 11 says that so many quarters have come. It's not disclosed to anybody. And Khata is now being changed by mutation at Annex G. Para 11. The Eastern Commissioner page number illa na right. Page number papers illa sari idu. ಏನು ಇಲ್ಲ ಕೈ ಕೊಡಿಲ್ಲ ಪೇಜ್ ನಂಬರ್ ಇಲ್ಲ ಇದು ಪ್ಯಾರಾ 11 ಯಾವ ಪೇಜ್ ಬರುತ್ತೆ Eastern Commissioner order ನೋಡಿ. However, from the foregoing discussion, it is amply clear that number of public and government structures exist in the said land since 36. Since many years, including a temple, drinking water structures, government PU college, government primary and secondary school, playgrounds, Hubli being the remote place of the so and so backward talukas, Mysore district, inhabited primarily primitive tribes and scheduled caste population. But
order, see, it was an order of status quo.
That you would have heard in Malurs then.
Where was the need to?
They have filed an application and memo documents.
Correct.
Work is stopped.
Where was the need to see order of status quo in such situation was better, isn't it?
Application to hear ಮಾಡಿದ್ರ.
Just because they filed an application and said that constructions were made and other things.
They have filed.
If that order of status quo was in favor of both the parties. If the construction was already there, then there was nothing.
Very construction ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Ongoing work of the scheme, it should be stopped seeking.
Sir, then how did you permit the other constructions to come up on your land?
ನಾನು ದೇವಸ್ಥಾನಕ್ಕೆ ಬಿಟ್ಟು ಬಾಕಿ ಯಾವ್ದು ಕನ್ನಡ
ದೇವಸ್ಥಾನಕ್ಕೆ ಮತ್ತೆ ಇದು
ದೇವಸ್ಥಾನದಲ್ಲ ಎಷ್ಟೋ ಗವರ್ಮೆಂಟ್
ಸ್ವಲ್ಪ ಜಾಗ ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ
ಒಂದಲ್ಲ ಒಂದು 10 ಬಿಲ್ಡಿಂಗ್ ಬಂದಿದೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಬಿಲ್ಡಿಂಗ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಫಾಲ್ಸ್, ಬಿಲ್ಡಿಂಗ್ ಬಂದಿಲ್ಲ.
See, you have said.
ನಾವು ದೇವ್ ಹಾಂಟಿಕ್
Please see, sir, your cost title, respond number 5 is the president of Madheshwara Temple Samiti.
ಟೆಂಪಲ್ ಸಮಿತಿ ಇದೆ. ನಾನು ಟೆಂಪಲ್ ಕಟ್ಟಕ್ ಮಾತ್ರ ಮಾಡಿದ್ದು ಹೊರತು ಟೆಂಪಲ್ ಸಮಿತಿ ನಾಟ್ ರಿಜಿಸ್ಟರ್ಡ್ ಅಂಡರ್ ದಿ ಪ್ರಾವಿಷನ್ ಆಫ್ ದಿ ಆಕ್ಟ್. There is no committee existing.
No, when you have admitted that constructions have come up on your land.
ನಾನು ಅದ್ರ ಕೈಲಿ ಬರೋದು ಅದೇನಾಯ್ತು ಅಂದ್ರೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ದೇವಸ್ಥಾನ ಕಟ್ತೀವಿ ಅಂತ ಬಂದು ನಾನು ಸ್ವಲ್ಪ ಪೋರ್ಷನ್ ಮಾತ್ರ ದೇವಸ್ಥಾನ ಕಟ್ಕೊಳ್ಳಿ ನಮ್ಮನ್ನ ಪೂಜೆ ಮಾಡಕ್ ಬಿಟ್ರು. ಕೈಲಿ ಬರೋದು the same observation in the deputy commissioner order. ನಾನು ಸ್ವಲ್ಪ ಪೋರ್ಷನ್ ಅನ್ನು ನಾನು ಬಿಟ್ಟಿದ್ದೀನಿ. ಬಟ್ ಆದ್ರೆ ದೇವ ಅದನ್ನು ತಗೊಂಡವ್ರು ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ಮತ್ತೆ ಬೇರೆ ಬೋರ್ವೆಲ್ ಹಾಕೋದು ಮತ್ತೆ ಏನೋ ನೀರು ಎಲ್ಲ ಮಾಡಕ್ಕೆಲ್ಲಕ್ಕೂ ಬರ್ತಾ ಇದ್ದಾರೆ.
Let them come, we'll see.
ಏನ್ ಹೇಳ್ತೀವಿ? When it comes to the petitioner submits that although the deputy commissioner had passed an order of status quo on 27/4/2022, directing the parties to maintain the status quo on the ground Nevertheless, without hearing the petitioner's hearing, and at instance of the contesting respondents hearing, 2 and 6, the deputy commissioner has passed the impugned orders dated 8/6/2022, cancelling the order of status quo. Full stop. Next para. Consequently, there should be an ad interim order of stay of the impugned order.
What is the direct to maintain status quo? Whether it is revives or not, ಇನ್ನೊಂದು ಅದಕ್ಕೊಂದು interpretation. Lords may say that they should maintain status quo. ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರಿಗೆ ಅದು ರಿವೈವ್ ಆಗತ್ತೆ ಇಲ್ಲ ಅಂತ.
Dated 8/6/2022, passed by the deputy commissioner in revision petition number RP 93/2018 till the next date of hearing. Full stop. This order would reinstate the order of status quo passed by the deputy commissioner on 27/4/2022, till the next date of hearing.
Office.
Order was granted 1 acre of land. Application was made for conducting the body. No action was taken. The matter was taken up before the Honorable Court, and the writ petition was filed. And may I request your Lordship to kindly take the annexure A, that is the order passed by the Honorable Court. In the writ petition, they came up with the plea that this is within 15 kilometers radius from the Bangalore Corporation limit. Not only me, there are 65 persons who have been granted, and they wanted to take action only against me. Your Lordship may kindly take the annexure A, page number 12. The Honorable Court has made it very clear that if at all if action has to be taken, it has to be taken against all 65. Despite this order, they have, because I have approached this Honorable Court, they have pick and choose me to initiate action against me for cancellation of the grant. This is the specific order passed by this Honorable Court that the court, the authorities cannot take action only against me and others. It has to, if at all if they want to take action, they will have to take action against all. Despite this order, they have chosen to initiate proceeding only against me. Page 5, page number.
So you filed online application.
ಅದೆಲ್ಲ ಮಾಡಿದ್ದಾಗಿದೆ. ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾಗಿದೆ.
ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಈಗ.
ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ. Cancellation ಗೆ initiated proceeding annexure C.
We had permitted them.
Correct.
We had permitted them to.
Your Lordship are permitted. But your Lordship, may I request your Lordship to kindly take page number 12, madam. Page number 12. It is also noticeable.
That's all right, sir. I noticed that.
So, despite this order, that if at all they have to take action, they will take action against all. They have not taken action against anybody except me.
Sorry. ಅದಕ್ಕೆ
the order is that they will have to take action against all the persons.
If they proceed to pass any adverse order against you, you will have a ground. What should be done at this stage? We can't stay the proceedings.
But this is a clear violation of.
Let them proceed, sir. It will be in violation of the order of this court if they proceed only against you. Let us see what they will do.
The government.
I can't stay the proceedings.
No, stay ಮಾಡದಲ್ಲ. ಅವ್ರ ಆಕ್ಷನ್ ಎಲ್ಲರೂ ಮೇಲೆ ತಗೊಂಡಿದ್ದಾರೆ. ಅವು ಅದನ್ನೊಂದು ಅಲರ್ಟ್ ಟೈಮ್ ಮಾಡ್ತಾರೆ. ಈಗ
even if the answer is no, this proceedings cannot be stayed at this point of time. What is it that you want then?
How the authorities are.
What is your prayer, sir?
ನನ್ನ ಪ್ರೇಯರ್ ಇದನ್ನ ಕ್ವಾಶ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ದೀನಿ.
ಯಾವ್ದನ್ನ? Proceedings.
Initiation of the proceeding.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Initiated only against me.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
It can't be done. But whether they have acted arbitrarily or not, that has to be ascertained. For that purpose,
we will put them on notice in that order.
Yes.
But I'll dismiss the writ petition. Barkale. What happened to the Podi?
So ಮಾಡಿ
Huh?
ಮಾಡ್ಲೇ ಇಲ್ಲ.
ನೀವು ಅದರ ಮೇಲೆ ಏನು petition ಹಾಕಿಲ್ಲ?
ಯಾವ್ದು?
Podi work,
Podi application.
I had directed them
Yes, madam.
that nevertheless it will not preclude
Yes, madam.
this court from issuing directions to the respondent Tahsildar
Yes,
to consider the application made by the petitioner for Podi Durast work. However, it has been informed that these days the application for Podi work has to be done online.
That I
So
have
we
done it.
permitted you to
May-
file online
That
application.
I have done it, madam. I request you lordship to kindly take annexure C. madam.
ಸರಿ, ಅದ್ರ ಮೇಲೆ ನೀವೇನು ಪ್ರೇಯರ್ ಇಲ್ವಲ್ಲ ನಿಮ್ದು ಇದ್ರಲ್ಲಿ?
ಅಲ್ಲ, ಅದನ್ನ ಮಾಡದೆ ಇನ್ಫ್ಯಾಕ್ಟ್ ಅದ್ರ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ದೀನಿ.
Where is your prayer, sir?
No, I have initiated contempt proceeding because they are not completed. But annexure C may kindly visit. ಆ ಓಡಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಮೇಲೆ ಅವರು annexure C ಅಡಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 22 ಅದರಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ಜಾಲ ಹೋಬಳಿ ಮೀನ್ಕುಂಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39ರ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ 22/7/98 ಬದಲ್ ಹುಕುಂ ಸಾಗುವಳಿ ಸಕ್ರಮೀಕರಣ ಸಮಿತಿಯ ತೀರ್ಮಾನದಂತೆ ರಾಮಯ್ಯ ಬಿನ್ ಲೇಟ್ ದೊಡ್ಡಮುನಿಯಪ್ಪನವರಿಗೆ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುತ್ತದೆ.
Why should we not stay the proceeding? If I have made it very clear that if action is to be initiated, you initiate against all the 65 grantees.
I don't have papers. Another paper ಇಲ್ಲ, but I heard what he is talking about.
Copy ಕೊಟ್ಟಿಲ್ವೇನೋ?
Millers, if it is not there, Millers, they are bound to issue. They can't, Millers, already Millers, the observation is
So
there.
we'll call upon the Tahsildar.
Let's observe that Millers, he has to initiate. Already order is there, Millers. Once again, Millers, non-Millers taking steps against any other,
No,
would not confer any right on
But
him.
let us find out.
Yes,
When I very clearly stated
yes.
that such random action smacks of arbitrariness and militates against the principles of equality enshrined in Article 14. I've said so. In spite of that, they want to take action only against one
It is
person.
his statement, Millers, so we do
No,
not.
no.
No, it's Miller's order, but we don't know, Millers, whether others against they have taken action or not.
Petition that it is taken only against.
I do not know, Millers, whether how he knows.
Only to that extent,
Yes.
I will adjourn the matter for
ಒಂದೇ ಪರ್ಪಸ್ ಈ ರಿಪಿಟಿಷನ್ ಹಾಕಿರೋದು.
learned AGA. Takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition on the learned AGA. Next para. Since the grievance of the petitioner is that in spite of there being a specific direction by this court in WP number 20722 of 2021 dated 24th of January 2022 that if at all action is to be initiated for cancellation of the grants, since a common ground is sought to be used against the petitioner, this court had directed that action should be initiated against all the 65 persons to whom grants were made in the 2 orders mentioned in the mentioned therein. So, nevertheless, it is submitted that action is initiated only against the petitioner. Under Rule 108K of the Karnataka Land Revenue Rules, 1966, and not against the others. We'll stop. Next para, learned AGA is directed to secure instructions from the second respondent Assistant Commissioner, Bangalore North Taluk, as to whether action is initiated only against the petitioner or against the other 64 persons, which was mentioned in the earlier order passed by this court. Release this matter on 21st of September.
Thought it of mandamus court against the respondent Tahsildar Lord, as per the order of the Assistant Commissioner, Lord, they're supposed to mutate the khata in the petitioner. That is the order of the Assistant Commissioner at Alexia Team, Lord, page number 11. But there was a bogus mutation, Lord, against the petitioner's property, but that was challenged before the Assistant Commissioner, Lord. But the mutation was set aside. Lord, the affirmative portion is page number 14. But the appeal is allowed further hereby ordered to set aside the IHC number 4 of 1984 and MR number 9 of 2001 and to mutate variant to accept in accordance with law. But thereafter, did not, I have given the representation to Tahsildar Alexia, page 10.
They would have filed a appeal.
They have not filed any appeal.
On the face of it, it is clear that you filed a appeal only in the year 2020.
Yes,
Calling in question MR
85.
number 84, 85 and 2001.
What happened, Lord? It was a bogus entry, Lord. Lord, there was no document whatsoever in favor of the respondent.
Therefore, unless and until the matter reaches finality, please hold yourself, sir. We can't issue directions like this.
There is no, and I find out, Lord, there is no appeal, Lord.
And you have not imputed the other parties also.
Plus, I'm seeking only direction against the respondent, Lord, mutate the khata. I'm not seeking any relief against the respondent, Lord.
In other words, you are seeking implementation of the order of the Assistant Commissioner.
Yes.
Is there no statutory right of appeal or revision for them?
Lord, it is them, Lord. Time period is only one.
Please wait, sir.
Only 60 days, Lord. I am not order was passed in January 2022.
ನೀವು 20 ವರ್ಷ 30 ವರ್ಷ ಡಿಲೇ ಆಗಿ ನೀವು ಅಪೀಲ್ ಹಾಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಬಹುದು.
That was a bogus.
You don't want to wait for even a few months.
Then Lord,
you should have at least implicated the parties. We would have issued notice.
I will implicate them, Lord.
Then implicate them.
Lord, they are not.
You implicate them. We will ask them whether they have filed a revision petition or they want to file.
Yes, Lord. I'll file my application.
You file application. At the oral request of the learned counsel for petitioner, the petitioner is permitted to implicate
respondent number, proposed respondent number 3 and 4, Lord.
Respondents number 3 and
4. One is GP Darshan Lal and Ramkrishna Reddy.
3 and 4.
Proposed respondent.
Allala, to implicate respondents number 2 and 3.
2 and 3 as a
In 2 and 3 India.
In RA,
Yes, Lord.
bracket BET, close 75 of 2020. As party respondents, number 3 and 4
to these proceedings. Full stop.
Learned counsel shall carry out the amendment in the cost right forthwith.
Yes.
Learned AGA takes notice for response number 1 and 2. Issue emergent notice to response number 3 and 4.
Returnable by 28th of September.
Yes.
Please carry out the amendment.
I will do it right now.
Yes.
And those petition note, application note is filed, seeking note for actually insertion note of a survey number. What happened is not this father got one Salvador Lobo Pinto filed an application for grant of occupancy rights. So that note was considered and way back in 1981 not tribunal granted not occupancy rights. After which in 2011, an application was filed not for correction or rectification of the survey numbers. You also find it at page 41. So that note I filed an affidavit saying that note I have no objection, note it can be allowed. According to note that rectification was allowed.
Where is that?
Page 45. The affidavit is at page 43. But I said not, I have no objection. With the correction, it has to be done.
What was the correction?
Correction note was of the few survey numbers note. We're wrong, page 41, if not to turn to the application. So there is a chart there. Land granted 142 for 1A, have been 141/1 year. Also changes with regard to survey numbers. I did not oppose it. Now, Lord, the tribunal allowed it. Lord, thereafter, in 2016, another application is filed, saying that Lord, when the land tribunal granted me the occupancy rights, one land, that is survey number 143/1A, measuring 1 acre 25 gunta, was left out, was not considered. And Lord, he seeks for grant of occupancy rights to that land. But for which, Lord, unfortunately, although Lord, I had engaged the lawyer and filed wakalat, Lord, I have not filed an objection. Some miscommunication between me and my lawyer. Ultimately, Lord, tribunal, Lord, allows the application. Lord, should turn to Lord, page 60. Operative portion, page 62. But tribunal did not say, Lord, in the affidavit that I had filed earlier, Lord, for correction, but I have said that this survey number is in this position. Therefore, tribunal says I am going to grant occupancy rate in respect of this land. My first submission is not in respect of this land. But one, the tribunal has already passed an order way back in 1981. If you are aggrieved by that order, his only remedy was to challenge that order. No doubt, Lord, there is a statement made by me in the earlier Lord application for correction that he is in Lord possession of the land, which is factually incorrect. However, Lord, that Lord affidavit Lord, cannot be a basis to allow the application because tribunal functions of issue. Secondly, Lord, the question of Lord inserting a new survey number now does not arise. In fact, Lord, I obtained a copy Lord, of the form number 7. Five Lord, point one. To say Lord, and the RTI, RTI is the nothing can be seen, Lord, in that application. Form number 7. But my submission is not that survey number is not there. Even assuming it was there, it cannot be granted at this point of time.
Page number 44 in affidavit para 6.
ಅದೇ ಇವರ affidavit.
Our affidavit ಅಲ್ಲಿ they agree that the certain same survey number can be granted to him ಅಂತ para 6 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವರೇ ಒಪ್ಪಿದ್ದಾರೆ. I have also no objection for granting the said land in the name of the petitioner. Para 6.
So in possession and cultivating the land. So they say, para 44, page 44.
Para 6, last line. Basis on this.
ಯಾವುದು ಸರ್ವೆ ನಂಬರ್
143/1A.
1A
1A.
1 acre 25 cents.
But I have said no objection, not in respect of the land which is seek for correction. Para 7. Rectification application filed by the person can be granted. Survey number 142 may be ordered to be changed survey number so and so, etc. So even assuming Lord, this is to be construed Lord as Lord statement on my behalf. Even then, Lord, tribunal has no jurisdiction.
Why did you make that statement?
I say, Lord, he did not realize what he was signing.
Learned HCDP take notice for response number 1 and 3. Issue emergent notice to respond number 2, returnable by 28th of September. Next para. Learned counsel for the petitioner submits that the impugned order dated 8/7/2022 at annexure K has been passed by the Land Tribunal, Mangalore, Dakshin Kannada district. Without hearing the petitioner, and the said order could not have been passed by the tribunal, since the tribunal became punctus officio no sooner the original order dated
24/11/1981. Sorry, 5/9/1981
was passed by the tribunal. So, merely because an application is filed stating that on an earlier application filed by the contesting respondents herein, seeking correction in the survey numbers and in the affidavit, dated
Affidavit was issued 6 August 2011.
6/8/2011, filed by the petitioner, he has admitted that the contesting respondents are in possession of survey number 143/1A, measuring 1 acre and 25 cents, the land tribunal has proceeded to pass the impugned order, although the application for correction was earlier allowed by the land tribunal and an order was passed on
27/8/2011.
Consequently, there shall be an ad interim order of stay of the impugned order dated 8/7/2022, passed by the land tribunal at Mangaluru, Dakshin Kannada district in PR 270 bar Roman 2, 457 bar 8182, till the next date appear. Please take it back. Please, you please give it in their presence so that they will also have a copy.
Before the Assistant Commissioner under Rule 108B of Rules Law. Because the kindly see the proceedings of the Assistant Commissioner Lord
Are seeking cancellation
Yes, my Lord.
of
Lords, what happened, Lords, regularization of land law. Lords was rejected by issuing endorsement to Lords that are not applicable. Lords, that was challenged before this court. Lords, the Lordship has considered and given liberty to appear approach before the Lord Assistant Commissioner under Rule 108. Lord, kindly see the order of your Lordship at page 243. Lord, operative portion at page 45, last time, Lord, consequently the petition stands dismissed as withdrawn, with liberty without the petitioner to file an appeal under Rule 108D, clause 6 of the rules for the Assistant Commissioner. Lord, accordingly, Lord, filed the appeal, Lord. Lord, it was Lord, kindly see Anagya A, page 30. It was filed on 28 March 2022, Lord. Since then, Lord, there is no sitting before the Assistant Commissioner. But therefore, Lord, simple direction, Lord, to dispose of the appeal at the earliest, Lord. I am seeking mandamus, Lord, to dispose of the appeal.
Tier 3, my lords. 28th March. Notice was ordered. Thereafter, my lords, a report of Tahsil was called on 22/6/2022. The matter is adjourned to 10 and 6
learned AG takes notice for both the respondents. Next para. The prayer in the writ petition is to issue a writ of mandamus directing the first respondent Assistant Commissioner, Tumkur subdivision, to dispose of the appeal filed by the petitioner in LND CR 1/2022-23 as expeditiously as possible. So, next para. Then counsel for the petitioner submits that when the petitioner had earlier approached this court in WP number 14476 of 2021, this court accepted the contention of the learned additional government advocate that the petitioner had an efficacious remedy in the form of appeal under section 108 capital D bracket 6 of the Karnataka Land Revenue Rules, 1966, and therefore dismiss the writ petition while granting liberty to the petitioner to file an appeal before the Assistant Commissioner. Full stop. Accordingly, the petitioner filed the appeal before the Assistant Commissioner on 28/3/2022. Stop. Learned Counsel submits that the Assistant Commissioner may be directed to expedite the hearing and conclude the proceedings. Stop. Next para. In view of the prayer made in the petition and the submissions of the Learned Counsel for petitioner, this court is of the considered opinion that no harm or prejudice will be caused to any person, if a direction is issued to the Assistant Commissioner to expedite the proceedings. Stop. Next para. Consequently, the writ petition stands disposed of with the direction to the respondent Assistant Commissioner, Tumkur subdivision to hear and conclude the proceedings in LND number so and so as expeditiously as possible, and at any rate within a period of 2 months from the date of receipt of a copy of this order. Stop. Ordered accordingly.
For example, mandamus, my lord, the rectification of the order one, that is the landing question was re-granted by the region Abolition Act, the Abolition Act, the year 1963, my lord. And subsequently, my lord, the Kata revenue interest have been transferred under MR number 1/1970-71. Hello, enter the details in the order one, my lord. The entire land has been entered in column number 7 by B and C. They are not in the A. Actually, the land in question, the entry should be put in the column number 5A. But the entry made in the order, my lord, it is fairly in the annexure, my lord. F, annexure F, order one. Annexure B is the re-grant order, my lord. Annexure F. In the column number A, my lord, it is put in vacant. And B and C, same extent it is, means 5 acres 2 guntas, 5 acres 2 guntas. Column number F is the page number 20, my lord. In the column, the bifurcation of the land, if it is a Karab and other A Karab, B Karab, Iduvali land, there must be the entry. When the entire land is Iduvali land, it should be entered in the column number A, 5A. But they have entered in column number 5B and 5C. They are not at all entered in 5A. Therefore, the petitioner gives the representation to rectify this, the Akar one. Rules 36 of the land revenue rules, whenever they came to discover this mistake, it is on the duty cast upon the revenue authority to rectify the mistake.
This is really correct. I work.
Artificial birthday, but the Akar Vandal Basalam, 11 sketch to Poison or there are transaction. Akar is the artificial correct. Akar Vandal rectification.
Learned AGA. Notice for all the respondents. Learned Counsel for the petitioner is directed to serve a copy of the petition on the Learned AGA. Next para.
Based on the grant, let them verify.
No, I will adjourn the matter. You please secure instructions. Next para. Learned AGA. Allah, the grievance of the petitioner is that although the name of the petitioner is entered in the land records pursuant to occupancy rights granted way back in the year 1963. Nevertheless, in the Aadhaar Band, since the entire extent of 7 acres and 2 guntas is shown in column number 5B and not column number 5A, the authorities are stating that 11E sketch cannot be prepared and the OD and Durust work also cannot be carried on. Stop. Then AGA is directed to secure instructions. The from the Assistant Director of Land Records, Malur Taluk, regarding the grievance of the petitioner. Stop. Release this matter on 21st of September.
Number 240.
Paper fifth respondent may not in this case. Fifth respondent in this case.
Yes.
Belongs to your lordship against the petitioner great grandfather Chaudappa and fifth respondent's father Venkateswamy. In respect of that, there is no dispute. Then during their lifetime, it was divided into 2 equal shares. That is 2 acres 35 guntas fell into the share of Chaudappa and 2 acres 35 guntas into the Venkateswamy. Then Venkatamuniyappa, he had 2 wives. That is namely Munivenkatamma and Changam. After the death of Venkatamuniyappa, they sold this property in favor of the petitioner's great grandmother Venkatamma under the registered sale deed dated 27/5/1953. The offshare belongs to Chaudappa. There is no dispute. In respect of this Venkatamuniyappa share, that is the 2 acres 35 guntas, his wife on the death of Venkatamuniyappa, both the wives are sold in favor of Venkatamma. Then your lordship can see on the death of Venkatamma, her daughter Hiriyamma is inherited this property. Then Hiriyamma on 3/7/1991 executed a will in favor of her 2 daughters, that is 2 wills, dividing this property for an extent of 1 acre 17.5 guntas and 1 acre 17.5 guntas in favor of Parvathamma and Sharadamma. Then your lordship can see on May 2, 2009, Parvathamma executed a registered deed in favor of the petitioner in respect of 1 acre 17.5 guntas, and he is the son of the Sharadamma. Because of he inherited the 1 acre 17 guntas, he became the owner of 2 acres 35 guntas. Now your lordship can see by suppressing all these facts that the 5th respondent, after the death of their father, he filed an application for the Tahsildar, got the property by way of commodity works. Without issuing a notice, Tahsildar passed the order and changed the kata in the name of this 5th respondent. Then thereafter, lordship can see the appeal was preferred before the Assistant Commissioner. Assistant Commissioner set aside that order, and thereafter, lordship, they preferred the appeal before the revision before the Deputy Commissioner. Deputy Commissioner set aside the order on the ground that there was a suit in OS number 207 of 2009, that is in between the family members of the petitioners, wherein a suit was filed, suit for partition was filed. wherein that the party was stood in the name of Venkateswara because it is not available for partition. They are not the parties. Fifth respondent is not a party. Because of that, the share was not given in respect of 2 acres 35 hectares. On this ground, DC has set aside the order of the state. Against that order, that is given. ADD is 27/5/1953. The Khata was affected in J's name. Your Lordship will see annexure B, my lord. Annexure B. That in respect of 2 acres 35 guttas, Parvatama and Shardama.
You are not a party to the suit. You are not a party to the suit.
I am a party to the suit. My family members have filed a suit for partition. That respond number 5 is not the party. Respond number 5 is not the party. Here, the entries made in the name of that respond number 5 after the Tahsildar. That copy was produced before the trial court. Because of that reason, Tata stood in the name of this fifth respondent. Because of the reason, this property was not available for partition, and the suit is dismissed in respect of 2 acres 35 hectares. Respondent is not a party. Respondent number 5.
So that is taken as a ground that in the decree you have not been granted the share.
Share.
Okay.
My lords, I appear for the respondent number 5, my lords.
Yes.
I appear for respondent number 5.
Yes, yes.
The Tahsildar, when he passed an order in their favor, entries were in my name, my lords. Entire 5 acres was mine. I had sold part of the land to them. They are claiming the remaining land also as them. I only sold 2.5 acres to them. I have not sold the entire 5 acres. Your lordship may have it on Monday or tomorrow. I will kindly make submissions in the matter.
Sir, 2.5 acres had already come to the share of his mother.
That is wrong.
In terms of a will left behind by the grandmother.
Your lordship may pass over the matter. I will argue at 2:30. Today itself I will argue. I will demonstrate it is not. Earlier they had not got it. It's false, my lords. I will argue at 2:30. Kindly have it at 2:30.
You please come tomorrow then.
Tomorrow.
Today, 2:30 we have other matters.
Please.
You please come tomorrow.
Please. I'm sorry I got the file just now. I was not in station. I'm sorry.
Learned AGA takes notice for response number 1 to 4. Learned Counsel VM Arun has entered appearance for respond number 5. Learned Counsel for the petitioner is directed to serve a copy of the petition on the Learned AGA. Next para. At the request of the Learned Counsel for respond number 5, release this matter tomorrow.
Grateful.
Yes.
At form number 50, derived in the year 1991, annexure A, that is for the grant of land of 4 acres, annexure A. The proceedings of the committee were held in the year 1993, and an endorsement was issued by the Tahsildar that it appears to be a Parambu forest land. It cannot be granted. That was taken in appeal before the Assistant Commissioner, and the Assistant Commissioner remanded the matter with a direction to hold a spot inspection and to give a clear report. By that time, there was a denotification annexure. Before that, on 5/8/1981, annexure F. This particular survey number, which was earlier numbered as survey number 154, was denotified by the Forest Department. Kindly see page 33. it was 30. It's a gazette notification. At the ink is 33, bottom, delete the existing survey numbers in the schedule 143, 74, 33, 1A, 22/1A, 13 12 bar 1 and 88 of declared village and 154 of Aitur village. These are deleted. My lord, even when it was brought to the notice of the authorities, they would not consider the application. And there were correspondence with the forest department itself to inform the Tahsildar that why are you troubling me, troubling the department? This survey number 154, which is later numbered as 176, is not a forest land. That is found at page 39. Page 39. And the forest department also informed you have granted land in this page 39, which subject is Aitur Gramada survey number 176 ಅಕ್ರಮಣ ಸಕ್ರಮದ ಬಗ್ಗೆ ನಿಮ್ಮ ಪತ್ರ 31/3/98 ಕುರಿತು. Kindly come to page 41. Last but one paragraph that is reference to ಉಲ್ಲೇಖ 9 ನೀವು ಬರೆದ ಪತ್ರ ಮತ್ತು ಅದರಲ್ಲಿರುವ ಜಿಲ್ಲಾ ಅರ್ಜಿಗಳನ್ನು ಸರ್ವೆ ನಕ್ಷೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಈ ಅರ್ಜಿಗಳು ಜಮೀನು ಮಂಜೂರಿಗಾಗಿ ಐತೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 176ರಲ್ಲಿ ಕೋರಿಕೊಂಡದ್ದಾಗಿರುತ್ತದೆ. ಈ ಸರ್ವೆ ನಂಬರ್ 176 ರಿಜಿರಾಜ್ ಮತ್ತು ಐತೂರು ಗ್ರಾಮದ ಅರಣ್ಯ ರಚನೆ ನಡೆಸುವುದಕ್ಕೆ ಸೇರಿರುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 154 ಎಂದು ತಿಳಿಯುವುದಾದಲ್ಲಿ ಅಂದ್ರೆ ಮುಂಚಿನ ನಂಬರ್, ಆ ಸರ್ವೆ ನಂಬರ್ ಅನ್ನು ಅರಣ್ಯ ರಚನೆಯಿಂದ ಈಗಾಗಲೇ ರದ್ದುಪಡಿಸಲಾಗಿದೆ. ಅರಣ್ಯ ಕಡತದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 154ರ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಅರಣ್ಯ ರಚನೆಯ ಬಗ್ಗೆ ಯಾವ ದಾಖಲೆ ಇಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 176ರ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಅರಣ್ಯ ರಚನೆಯ ಬಗ್ಗೆ ಯಾವ ದಾಖಲೆ ಇಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 176ರ ಪಹಣಿ ಪತ್ರಿಕೆಯಲ್ಲಿ ಕಲಂ 9ರಲ್ಲಿ ರಕ್ಷಿತ ಅರಣ್ಯ ಎಂದು ದಾಖಲೆ ಇಲ್ಲ, ಬದಲಾಗಿ ಸರಕಾರಿ ಎಂದು ದಾಖಲಾಗಿದೆ. ಕಲಂ ನಂಬರ್ 11ರಲ್ಲಿ ಸುರಕ್ಷಿತ ಕಾಡು ದಾಖಲಿಸಿದೆ. ಆದರೆ ಈ ಸರ್ವೆ ನಂಬರ್ 176ರ ಪಹಣಿ ಪತ್ರಿಕೆಗಳನ್ನು 1990ರಿಂದ ಪರಿಶೀಲಿಸಿದಾಗ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿ ವಿಸ್ತೀರ್ಣವನ್ನು ಕಳೆದುಕೊಂಡು ಬರಲಾಗಿದೆ. ಈ ಹಿಂದೆ ಈ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ನೀವೇ ಮಂಜೂರು ಮಾಡಿ ಸಾಗುವಳಿ ನೀಡಿದ್ದು, ಈಗ ಉಲ್ಲೇಖ 9ರ ಪತ್ರಕ್ಕೆ ಲಕ್ಷೀಕರಿಸುವ ಅರ್ಜಿಗಳಿಗೆ ಮಾತ್ರ ಸಂಶಯ ಬಂದಿರುವುದು ಏಕೆಂದು ತಿಳಿಯದೆ ಈ ಸಂಶಯವನ್ನು ನೀವೇ ನಿವಾರಿಸಿಕೊಳ್ಳಲು ತಿಳಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ನೀವು ತಿಳಿಸುವ ಎಲ್ಲಾ ಅರ್ಜಿದಾರರ ಜಮೀನುಗಳು ಅರಣ್ಯ ಇಲಾಖೆಯ ಕೈರಾಣಿಂದ ಹೊರಗೆ ಇರುವುದೆಂದು ನೀವೇ ತಿಳಿಸಿದ್ದು, ಆ ಜಮೀನುಗಳು ಸರ್ಕಾರದ ಜಮೀನು ಅಥವಾ ಅರಣ್ಯ ಇಲಾಖೆಯ ಜಮೀನು ಎಂದು ಅರಣ್ಯ ಇಲಾಖಾಧಿಕಾರಿಗಳೊಂದಿಗೆ ಚರ್ಚಿಸಿ ನಿರ್ಧರಿಸಿ ಮಂಜೂರಿಗೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ತಿಳಿಸಿದೆ. ಈ ಬಗ್ಗೆ ಇನ್ನು ಮುಂದೆ ಪತ್ರ ವ್ಯವಹಾರದ ಅಗತ್ಯವಿಲ್ಲವೆಂದು ತಿಳಿಸಿದೆ.
Why have they not mentioned about that notification that you have pointed out?
ಅಲ್ಲಿ 9ರಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ. And the grant of these some of the persons who are granted with the land, a public interest litigation was filed before this honorable court in the next election. In that, the government made a statement that it is not a forest land. That is at page 43. Annexure. When we see page 50. PAL is filed by Puttur Taluka Parisara Sanrakshana Vedike, claiming to be a voluntary organization formed with the object of protecting the environment in the district. It is alleged that the land banking survey number 156 of Puttur Taluka district is a forest land measuring about 1,236 acres, and it is thickly wooded and situated in the hill ranges of Western Ghats, where the rainfall is higher than the rest of the state. The 6th respondent on applications filed by respondent 7-43 without holding an inquiry granted regularized the forest land in their favor. Hence, it has filed the petition for a declaration that the grant the regularization of forest land in survey number 176 of Aitur district to respondent 7-43 is illegal and ultra-virus. It's a public interest litigation. Now, objections have been filed by respondent 8243 denying the facts and challenge. It is stated that the writ petition is totally misconceived and no in order. Detailed for now kindly skip that may not for
ಆಯ್ತು. What is annexure J? Annexure J, next order.
Next order, a similarly placed person had come before this honorable court and this honorable court directed the Tahsildar to place the application before the land committee and then to pass an order. In survey number 176 itself, that is the order. That in page 57, this honorable court. Accordingly, the impugned order, I am at page 57. Endorsement dated 22/3/2006 stands firm. The matter is remitted to the Tahsildar to place the applications of the petitioner before the land grant committee of such committee being constituted. Thereafter, the committee shall consider the case of the petitioner in accordance with the. Until such consideration by the committee, status quo with regard to the position which exists as on today shall be maintained. My lord, a similarly placed person who had given application, to him the Sagwadi chit is issued as per annexure E. Annexure E at page 28.
Annexure J.
Annexure E is the Sagwadi chit in respect of the land.
Annexure?
Annexure E. Kitchener had filed an application for grant of land. And by the time it came for consideration, he was no more. And Sagwadi chit was issued to. It was dated on 13/5/1993. Sagwadi chit. And kindly see the at page 31, the land. Details of the land granted. Survey number 176/1B, Pushki 1.20 acres, 176/1C, Pushki 2.50 acres. And the petitioner represented as per annexure K, whether it is the year 2016, that requesting that his application may be considered. Annexure K. ನಾನು ಐದೂರು ಗ್ರಾಮದ ಬಾಬು ಸರ್ವೆ ನಂಬರ್ 176 ಅಂಶದ ಆಸ್ತಿಯನ್ನು ಕಳೆದ ಹಲವಾರು ವರ್ಷಗಳಿಂದ ಕೇರಳ ಕೃಷಿ ಕೃತಾವಳಿಗಳಾದ ಅಡಿಕೆ, ತೆಂಗು, ರಬ್ಬರು, ವಾಸ್ತವ್ಯದ ಮನೆ ಕಟ್ಟಿಕೊಂಡು ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇನೆ. ಈ ಆಸ್ತಿಯ ಕುರಿತು ಈ ಕಚೇರಿಗೆ SCR 373/91/92ರಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದ್ರಿ ಅರ್ಜಿಯಲ್ಲಿ ಅಕ್ರಮ ಸಕ್ರಮ ಸದಸ್ಯರು ಮಂಜೂರಿಗೆ ಶಿಫಾರಸು ಮಾಡಿದ್ದು. ಇಟ್ ವಾಸ್ ರೆಕಮೆಂಡೆಡ್. ತದನಂತರ ಈ ಆಸ್ತಿಯು ಸುರಕ್ಷಿತ ಅರಣ್ಯದ ಮಿತಿಯಲ್ಲಿದೆ ಎಂದು ಶರ ಹಾಕಿ ಅರ್ಜಿಯನ್ನು ವಿಲೆ ಇಟ್ಟಿರುವುದರ ವಿರುದ್ಧ ಅರ್ಜಿದಾರರು ಮತ್ತು ಇತರರು ಮಾನ್ಯ ಸಹಾಯಕ ಕಮಿಷನರ್ ಕಚೇರಿಯಲ್ಲಿ ಮೇಲ್ಮನವಿ ನಂಬರ್ 2 ಅಪೀಲು ಸಲ್ಲಿಸಿದ್ದು, ಮಾನ್ಯ ಸಹಾಯಕ ಕಮಿಷನರು 30/8/2000 ಆದೇಶದಂತೆ ಈ ಮೇಲಿನ ಅರ್ಜಿಯಲ್ಲಿ ಸೂಕ್ತ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ಆದೇಶ ಮಾಡಲು ತಮ್ಮ ಕಚೇರಿಗೆ ನಿರ್ದೇಶನ ನೀಡಿ ಆದೇಶ ಮಾಡಿರುತ್ತಾರೆ. ದಟ್ ಈಸ್ ಎಲೆಕ್ಷನ್ ಟೀಮ್. 1000 is the assistant commissioner has ordered that to go there, inspect, verify, and then pass order. It's not been done. All others, most of them are granted with land. The Sagwadi chit has been issued.
Yes. What do you say?
Application is filed, my lords, in the 1991. They have not pursued their right, my lords, never. The others, my lords, what is produced all these documents relating to some other applicants, similarly placed persons. The stand taken by the state government in the PIL, my lords, saying that it is not the forest and granted land is outside the purview of the forest land. And subsequent order at annexure J, my lords, also allowed on the ground, endorsement was cautious of Tahsildar on the ground that it lacks material particular in that particular endorsement, stated whether it is forest or not. On that ground, his position was protected and matter is remitted back. Here, after so many years, in 2016, they have come before this honorable court.
Application is still pending.
That and status of the land, nowhere it is clear that whether it's one of the denotification they have produced at annexure. This is required to be seen by the authority. Delay is one of the
similar orders have already been issued. So they will have to verify what has happened to those cases after the matter was remanded. Whether they were considered and lands were granted
in annexure
after finding that these are not forest land.
Even in annexure D, extinguished order, whether the petitioners were parties or not.
It
is not.
Allah, not necessary. He did not be a party there. But he has a right to get his application considered.
91 in the year.
Even today, many such applications are coming before this court. Maybe it was considered earlier, rejected, it was challenged. So many things may be there. But at any rate, even the authorities will not be able to use it for any other purpose if it is found that such an application is pending.
And he should meet all the requirements of law. He should be in cultivation.
That they have to find out.
Yes. Very
Perfect.
Including the forest, because it is not very clear that.
Including the forest department itself has said, Nange innu mele tondre kodbedi ee vishayada bagge anta alli tanake kelidare.
Learned AGA takes notice for all the respondents. The grievance of the petitioner is that his application filed in form number 50 on 5/8/1991, at annexure A, seeking grant of 4 acres of land in survey number 176 of Aitur village, Puttur Taluk, Dakshin Kannada district, remains unconsidered even till this date. Stop. Learned counsel for the petitioner has drawn the attention of this court to several documents filed along with the memorandum of writ petition, saying that there was some confusion in respect of survey number 176 of Aitur village, that it is a forest land. So, one such public interest litigation was also filed before the Honorable Division Bench in WP number 35789 of 2000, and the Honorable Division Bench by order dated 26/9/2001 took note of the
We have taken the stand.
Yes. Ministry of Forest and Environment has taken a stand that it is not a forest land. But of 3.
Allah, that is Union of India.
Yes.
Union of India cannot.
No, yes, Ministry of Environment and Forest.
Correct. Union of India.
Forest. Yes.
Correct. But how can they come and say whether this is a forest land or not? What was the stand of the state government?
State government, they had not filed the objection. They had not filed it. But the forest MOEF has filed a statement that it is not a forest land. Reserve forest area.
Respond number 2
Maybe by that mistake, I don't think Union of India would have come and filed objection to that.
I appeared in this matter.
Allah, what was the stand of the stand of the government was more important, not the stand of the Union of India.
They filed the statement of objection.
Yaro?
The Union of India.
No, but what was the stand of the government?
Government had not filed the statement.
Their stand was more important, isn't it? How can Union of India come and say before this court, no, this is not a forest land?
After that, there is 1981 itself, there is a denotification. They are not proceeded with the performance.
Sorry,
Yes.
there is no reference to all that document here. Let us note whatever is there in the order.
Yes. Single judge takes note of that order.
Petition has drawn the attention of the court to several documents filed along with the memorandum of writ petition, saying that there was some confusion in respect of 176 High Court delay, that it is correct that one such public interest litigation was also filed before the Honorable Division Bench in WC number 789 of 2000, and the Honorable Division Bench by order dated 26/9/2001 took note of
The stand taken by the Union of India, Ministry of Environment and Forests, that the lands granted to respondents number 7 to 43 therein in survey number 176 of Aitur village was not part of the reserved forest area, and the same is outside the demarcation line. So, in another case, in WP number 9489 of 2008, this court, by order dated 13/7/2009, held that the endorsements issued by the committee, by the Tahsildar, rejecting the application on the ground that the land is a forest area, was without any basis. So therefore, while setting aside the endorsement issued by the Tahsildar, the matter was remitted to the Tahsildar to place the application of the petitioner before the land grant committee, and the committee was directed to consider the case of the petitioner. So, it was also directed that until such consideration by the committee, status quo with regard to the possession which exists as on the day shall be maintained. So, next paragraph. Then AGA, on the other hand, submits that this is the first time that the petitioner has woken up after it is contended that he filed an application seeking regularization, way back in the year 1991. Stop. Next para. Having heard the learned counsel for petitioner, the learned AGA, and on perusing the petition papers, this court finds that at any rate, the petitioner is entitled to have his application filed in form number 50 considered. Stop. However, the committee is required to secure records and reports of the revenue authorities as well as the forest authorities, to find out as to whether the land in question falls within the forest area or if it is situated within any prohibited distance from the forest area, and thereafter pass necessary orders. Stop. Next para. Consequently, the writ petition stands disposed of with the direction to the second respondent, Tahsildar, Kadaba Taluk, to place the application of the petitioner before the Committee for Regularization of Unauthorized Occupation, along with a report. Stop. The Tahsildar shall verify from the records and consult the forest officials to find out whether the land in question is within the forest area or outside. Stop. The Tahsildar shall place the application with all such report before the committee as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Stop. The committee shall thereafter consider the application of the petitioner and if need be secure records from the forest officials or find out if there was any objection raised from the Department of Forest and thereafter pass necessary orders in accordance with law, as expeditiously as possible and at any rate within a period of 3 months from the date when the application is placed by the Tahsildar before the committee. Ordered accordingly.
Application for conversion is rejected on the ground that master plan is not finalized. Picture D, page 57 is
Yavur idu?
Malur.
Malur. We have passed similar order.
Please, annexure email.
So similar orders.
Please.
Learned AG takes notice for all the respondents. Same as WP number 858 of 2022, dated 19th of January 2022.
Annexure E is D series.
Yes.
13 also same.
All. Huh? Yenappa? You didn't file an appeal before the KAT. Okay. Go before the Assistant Commissioner. 14-15. Yes.
Number 16, Prakash Imaj.
Yes. AGA. What's the order dated 26/7/2022? Annexure P. Matter is called out. There is no representation for the petitioner. Release matter on 19th of September.
PM.
Yes, Mr. Sidmallappa.
Lord, the petitioner has purchased the land bearing survey number 211, Lord, of Kalya village under a registered sale deed dated Lord 13/10/1993, annexure B. Lord, the annexure A, Lord, the RTC, Lord, it shows that Lord, the entire land tax, Lord, the total measurement of 6 acres, 29 guntas, including 5 guntas of Kara. Lord, without there being any Lord, reasonable cause, Lord, a show cause notice was issued by the Tahsildar against the petitioner saying that Lord, he has encroached survey number.
How did your vendor acquire title?
Lord, it is his ancestral property. Lord, the RTC mutation stands, Lord, when Lord the sale was executed in his name to the extent of 6 acres, 29 guntas.
Sorry. Either. Second respondent issued show cause notice. Tahsildar issued show cause notice.
Lord,
to appear before the authority to show cause by legal action.
Lord, I have given my reply. I stated that no encroachment, Lord, I am well settled in survey number 211 only. And no question of Lord, my extension of Lord position to the land bearing survey number 212. It is nothing to do with me. Lord, no surveys, Lord, prepared, no inquiry. Lord, arbitrarily, Lord, it was held that I am encroached in 16 guntas of land in survey number 212. Lord, my reply was not considered, and there is no opportunity for me to have any summary inquiry.
5 acre 29 guntas. In RTC, it has come as 5 acre only. 29 guntas, you are saying that it is encroachment. I have filed an application for rectification of that. Till that is considered, you don't proceed on that. His application is based.
I have also filed application.
Scale deed is there. Copy of the scale deed is there.
ಅದು ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಪೇಜ್ 26 ಅಲ್ಲಿ 5 ಎಕರೆ 29 ಗುಂಟೆ
ಇದೆಯಲ್ಲ
ಅದೇ RTC annexure C RTC ದಲ್ಲಿ 5 ಎಕರೆ ಕೃಷ್ಣಮೂರ್ತಿ
Five acres, Lord, my purchase is not 5 acres, 29 guntas. Out of 6 acres, 29 guntas.
NC Vishwanatha.
He was my vendor. Lord, annexure A, Lord, refers to Lord, the revenue entry stands in the name of my vendor. Lord, it.
Allah, if you see annexure A, page number 17. RTC, ಅದರಲ್ಲಿ NC ವಿಶ್ವನಾಥ್ ಸಣ್ಣ ಚೆನ್ನೇಗೌಡ 5 ಎಕರೆ 29 ಗುಂಟೆ ತೋರಿಸ್ತಾರೆ. So even your vendor had acquired under a registered sale deed.
Lord, it refers to Lord, refers to a sale deed.
Not by inheritance.
No such sale deed, Lord.
6 ಎಕರೆ
ಅಲ್ಲಲ್ಲ ಅದ್ರಲ್ಲಿ ಟೋಟಲ್ ಇರೋದು 6 ಎಕರೆ 29 ಗುಂಟೆ.
NC ವಿಶ್ವನಾಥ್ ರೌಂಡ್ ಆಫ್ ಮಾಡಿದ್ದಾರೆ.
ರೌಂಡ್ ಆಫ್ ಮಾಡೋದು
529 MR
ರೇವಣ್ಣ ಅವ್ರದ್ದು ಮಿಕ್ಕಿದ್ದು ರೇವಣ್ಣ ಅವ್ರ ಹೆಸರಲ್ಲಿದೆ.
ರೇವಣ್ಣ ಅವರು
20 ಗುಂಟೆ ರೇವಣ್ಣ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ತಾರೆ.
If that is the position, How can they now say, no, this is encroached upon?
Like this Yoka's notice and the treat madli.
He has given a reply. He has given a reply.
ಅಲ್ಲ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಕರೆಕ್ಷನ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲ ನಾನು
Sure, yep.
ರಿಪ್ಲೈನು ಕೊಟ್ಟಿದ್ದೀನಿ.
Then
Reply
application.
and
There is that only one. Still that is considered, you can't proceed.
What is this annexure G?
Annexure G.
Impugned order.
Other impugned order. The second prayer may be kind. This mandamus directly respondent consider
Allah,
that
this order is passed on what? On the show cause notice or on the application given by the petitioner?
the encroachment ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ. Clear the encroachment and so and so. ಅನಧಿಕೃತವಾಗಿ ಸರ್. Thus, it may be treated as show cause notice. Let him place all these material before Tahsildar and then let him consider, including the issue of his application at annexure F, where he is seeking for correction of addition of 29 guttas. Thereafter, let him proceed.
No, from when it was left out?
ಏನು ಹೇಳಿಲ್ಲ ಇವರು ಏನು ಹೇಳಿ.
Where is your RTC, sir?
Lord, my application says not, I can read not second param not of page 31 annexure D.
Annexure C, page number 29. ಅದರಲ್ಲಿ 5 acres ಅಂತ ತೋರಿಸ್ತಾರೆ.
ಅಷ್ಟೇ ತೋರಿಸಿ.
ಅವ್ರು ರೆಫರ್ ಮಾಡೋದು ಈಗ 212. I have nothing to do with 212. I am only not having my right plot to the extent of 1 acre, 5 acres 29 gunta in survey number 129.
ಬರ್ಕೊಳ್ಳಿ. Learned AGA takes notice for 190. Why this Gram Panchayat?
Lord, the Gram Panchayat, Lord, I was directed to hand over position to Gram Panchayat.
What a complaint.
Impugned order says, Lord, it has to be handed over to Panchayat. Panchayat has nothing to do with this. The impugned order not passed by the Tahsildar. I've been directed to hand
Takes
over
notice
this
for
portion.
response number 1 and 2. Learned counsel for the petitioner submits that since it was mentioned in the impugned order dated 23/8/2022 annexure G. ಇಲ್ಲ ಹೇಳಿದಾರ ಆ ತರ ಎಲ್ಲ ಹೇಳಿದಾರೆ ಅವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ ಅಂತ.
Lord, the show cause notice says, I can read the show cause notice. Annexure D, page 30. Lord, the ವಿಷಯ ಆದ್ಮೇಲೆ ಉಲ್ಲೇಖ ಅಂತ ಇದೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಕಲ್ಯಾಣ ಗ್ರಾಮ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ. It is on their application.
Since it was mentioned in the notice dated 35/2022 at annexure D at reference number 1 that there was a communication made by the Panchayat Development Officer of Kalya Gram Panchayat dated 1/10/2021, the Panchayat Development Officer has been implemented as respond number 3. So, however, there is no reference. Further, even in the impugned order at reference number 1, the name of the Panchayat Development Officer and his communication dated 1/10/2021 is shown. However,
The impound order doesn't say, my lord, any right not hold by panchayat over the property.
No relief is claimed against the third respondent, Panchayat Development Officer or the Gram Panchayat. Stop. Next para. Learned counsel for the petitioner submits that the petitioner purchased the land in question, measuring 5 acres and 29 guntas in survey number 211 of Kalya Village, Kasba Hobli, Magdi Taluk, under registered sale deed dated 13/10/1993. Stop. It is found from the RTC extract of the year 1993 to 1996-97 that the vendor of the petitioner, Shri N.C. Vishwanath, son of Chennai Gowda, also had acquired the land in question under a registered sale deed, and consequently his name was entered in the land records in terms of MR number 19/1985-86. So, the name of the petitioner was also entered in the land records in terms of MR number 20/1996-97. So, however, in the computerized RTC extract of the year 2021-22, the extent of land in favor of the petitioner is shown as 5 acres. Stop. In this regard, the petitioner has given a representation dated 10/3/2022 at annexure F to the Tahsildar, Magdi Taluk, seeking rectification of the mistake and to show the extent of land as 5 acres and 29 guntas, in terms of the registered sale deed.
According to us, it is kharab anta ಹೇಳ್ತಾರೆ. Kami anta ಹೇಳ್ತಾರೆ. Yes, continue with our thought. That also is the point.
Next para. In the meanwhile, a show cause notice dated 30/5/2022 is said to have been issued by the Tahsildar, stating that the petitioner has encroached upon the 16 guntas of land, 16 guntas of kharab land in survey number 112, and therefore the petitioner was called upon to answer why action should not be initiated against the petitioner for the alleged encroachment. Stop. Learned counsel submits that a reply dated 9/6/2022 was caused by the petitioner by stating that the petitioner is the absolute owner in occupation of 5 acres and 29 guntas of land in survey number 211 in terms of the registered sale deed, and that the petitioner has not encroached upon any other land, including the land in survey number 212, as was made out to be in the show cause notice. Stop. Nevertheless, the Tahsildar has proceeded to pass the impugned order dated 23/8/2022 at Annexure G, stating that the directing the revenue inspector to conduct a spot inspection, demarcate the encroached portion, if need be, with the assistance of the police, and after evicting the petitioner from the encroached portion, to take possession of the Kharab land. Stop. Then a counsel for the petitioner submits that the impugned order has been passed without affording an opportunity of hearing to the petitioner. So, moreover, the application filed by the petitioner seeking correction in the revenue records in terms of the registered instrument also remains unconsidered by the Tahsildar. Full stop. Next para. Learned AGA would submit that having regard to the documents submitted by the petitioner, the matter may be remanded back to the Tahsildar for reconsideration, while directing that opportunity of hearing should be given to the petitioner. Full stop. Consequently, the impugned order dated 23/8/2022 at Annexure G, passed by the Tahsildar, Magadi Taluk, in dispute bearing number NCR CR for 398/2021-22, semicolon, NCR CR for 199/2021-22 is hereby quashed and set aside. Stop. The matter is remanded back to the Tahsildar, Magadi Taluk, to reconsider the matter having regard to the application filed by the petitioner seeking rectification of the land records, and more particularly to incorporate 29 guntas along with the 5 acres in terms of the schedule shown in the sale deed under which the petitioner acquired title over the land in question.
Including the Miller's age.
Full stop.
Classification plan, there is we cannot.
The Tahsildar is required to have regard to the fact that even the vendor of the petitioner had acquired title under a registered sale deed, and the entire extent of 5 acres and 29 guntas was shown in the land records in the name of the previous owner. Stop. The Tahsildar is required to verify the survey settlement records in the presence of the petitioner and find out whether the 29 guntas of land which were sold to the petitioner includes 16 guntas of Kharab bracketally Bavi dash Kunte close bracket. Stop. In the Kharab portion, comma, including 16 guntas of Bavi dash Kunte is attached to the main land, comma, then it is not permissible for the Tahsildar to hold that the petitioner is in unauthorized occupation, comma, if the said 16 guntas of Kharab bracketally Bavi dash Kunte is attached to the main land. Stop. Even if it is A Kharab, even if it is B Kharab, he can't say that he is in unauthorized occupation. He will see it cannot be detached from the main portion, or he cannot seek.
Always ownership with the state. We can reserve for
it
public
continues
purpose.
to be vest with the state.
Yes.
But if it is attached to the
Can be used
mainland,
for any other public purpose.
Ah. ಹೌದು. But it cannot be held to be for public purpose. Allah. See, say suppose there is a pathway, which is also a B Kharab, which cannot be disposed of. But even if the person seeks conversion of the land or permission to cultivate the land, permission can be given in respect of A Kharab land. But permission cannot be given in respect of B Kharab land. But it continues to vest in the attached to the mainland. But he cannot say it's an encroachment. Encroachment at the how will he divide it and take it away from the mainland? There is a pathway, it is there. It can be used by the public. ಆತರ ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಇದರಲ್ಲಿ, ಏನು ಹೇಳಿಲ್ಲ, ಏನು ಹೇಳಿದೆ?
You said 16 guntas of Kharab in the is attached to the mainland.
The Tahsildar cannot hold that the petitioner is in unauthorized occupation of the same. Stop. No doubt. The Tahsildar may pass orders in accordance with law. If it is found that the 16 guntas of Kharab, practically Bavi dash Kunte, is a acre of land which can be made use of by the general public. Including the petitioner. Stop. Next para. Ordered accordingly.
Please, Manna.
Yes.
The order connection. Wherein a portion of woman land but we granted in the seventh respondent the Panchayati. The purpose of establishing this treatment plant that just to move a tank ಕೆಳಗಡೆ ಅದರಿಂದ ಊರಿಗೆ ನಮ್ಮ ಪೆನ್ಷನರ್ಸ್ಗೆ ಇನ್ನು 20 ಮನೆಗಳಿಗೆ ಡ್ರಿಂಕಿಂಗ್ ವಾಟರ್ ಸಪ್ಲೈ ಅದರ ಮೇಲೆ just above that this land has been granted for the treatment plant by the second respondent without notice, without hearing, and this land is situated within the Gram Panchayati of Karnataka Gram Panchayat. The land that is now sought to be granted in favor of particularly Gram Panchayati, even though particularly Gram Panchayati has a number of lands which is their territorial jurisdiction.
Then this becomes a public interest litigation. What is your personal interest in respect of the land in question?
What is the loan from the land which is going to be affected? I am also affected.
That's what. Then it.
Some of the villages, not the entire village, only a part of the village.
It doesn't come under the provisions of this KLR Act, sir.
Under section 71.
71, no?
71. First dereservation of order. The dereservation order from Omar. That is extension under section 68. Extension of right of individuals over a public road. Under that the order is passed. And thereafter it is reserved for rain related treatment. Because of that it has been classified as KLR. Otherwise you would have become a local body.
Takes notice for response number 126. 126. Issue emergent notice to response number
6,
7 to 9. Returnable by 28th of September.
Let them not put a construction till then. I am not seeking stay of the order under it. Only restraint order from putting up construction.
It is not your property.
It is not my property.
If it is your property, you can make such a claim or make such prayer. It is not your property. So therefore, that is why I said the very basis makes it clear that it's a public interest litigation, not a private interest. Anyway, let us see. Let them come. If your private right was affected, then we could have considered.
Status quo may be maintained. I put the photograph.
No, no. See, there is a provision, and the state government itself has made it a policy and has issued directions to all the local bodies, including Gram Panchayats, to establish such solid waste management units.
Rules, my lords, criminal prosecutions are being initiated against these officers for not establishing.
Let us see.
In another instance, not put and granted into model also the
Yes. Yes, yes. Let us see. It all depends, sir. If it is a private property, if there is an allegation that they are trying to put up this construction, although I have made an application seeking regularization of that land, other case will have they have come before this court. Yes.
Of the respondents. Of entering the Kata, petitioner in accordance with the grant. Lord, petitioner is granted 3 acres 12 guntas in survey number 34 in Naiknandi. According to the OM, after the OM, as directed by the second respondent, has paid Kimmat of rupees 3,124. Subsequent to that, the land has been granted in the name of the petitioner. After that, the petitioner represented before the respondents many times, but they have not considered the representation of the petitioner in view of inserting the
For what?
Kata, to enter the Kata in them.
The Sagwali chit is issued.
Sure.
Where is it?
Annexure, my lord, page 17. Page 17. After paying the Kimmat as per the OM, annexure A is OM. Sagwali chit is issued. Subsequent to that.
So you are seeking entry of your name in the land record.
They are represented many times, but they are not taking any action.
So it will be the same as the morning one. They will have to verify from the original records. If it is found that the land is granted in their favor, then they have to go ahead and enter their name. If it is not found, then they have to go before the committee. Which is that serial number? Serial number 11. ಇಲ್ಲ ಅದಕ್ಕೆ ಮುಂಚೆನೆ ಬಂತು ಅಂತ ಇವು ರೇಣುಕಾಂತ್ ಕೆಲಮ್ಮ ಹೇಳ್ತಾರೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಮಿಸ್ಸಿಂಗ್ ಕಮಿಟಿ ಫಾರ್ ಮಿಸ್ಸಿಂಗ್ ಫಾರ್ ಬಿಲ್ಡಿಂಗ್ ಮಿಸ್ಸಿಂಗ್ ರೆಕಾರ್ಡ್ಸ್. ಎಸ್ ಎಸ್
I want to bring in this case, the proceedings also have been taken place while granting the land. That has been annexed.
ಅದಕ್ಕೇನೆ they'll have to verify from the original records. If it is found that it is genuine, then they will have to enter your name. Yes.
Annexed even page 23. The petitioner father granted the land under the Dharaka Community 30th 1965, page number 23. Till then, his father was cultivating the individual property. Till 1965. After his death, the petitioner is cultivating the property. According to the given representation, 61 to grant the land.
ಗ್ರಾಂಟ್ ಮತ್ತೆ ಏನಕ್ಕೆ ಗ್ರಾಂಟ್?
ಅಲ್ಲಲ್ಲ,
ನಿಮ್ ತಂದೆಯವ್ರಿಗೆ ಆಗ್ಲೇ ಗ್ರಾಂಟ್ ಆಗಿದೆಯಲ್ಲ, ಮತ್ತೆ ಇನ್ನೊಂದ್ಸರಿ ಏನು ಗ್ರಾಂಟ್? ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್
Where grant?
Where is your representation?
Page number 67.
ಏನ್ ಕೇಳಿದೀರಾ?
Grant of land, property, file number by way of Akrama Spectrum.
It has been granted in favor of another Srimati Gopamma.
2 acres land of land.
Ah.
He is not connected with the father of the petitioner.
Hmm.
He was nowhere related.
Ah.
to the But he has given representation and he has not at all constructed.
Granting ಮತ್ತೆ grant the prayer itself is incorrect. Now there is a dispute that the land which was originally granted in favor of your father was again granted in favor of another person.
The land only 2 acres of 2 acres master land.
2 acres 35 guntas.
Our land.
Ah.
He is not related to the father of the petitioner.
Correct. ನಿಮ್ಗೆ
ನಮಗೆ grant ಆಗಿದೆ. I have given representation.
ನಿಮ್ ತಂದೆಯವರಿಗೆ ಎಷ್ಟು ಗ್ರಾಂಟ್ ಆಗಿತ್ತು?
16 acres.
16 acres.
20 acres 11 gunta.
16 acres ಗ್ರಾಂಟ್ ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. ಯಾವಾಗ ಮಾಡೋದು ಹೇಳಿ ಅದು? 65 ಆಗ ಬರೋದಿಲ್ಲ. By that time 64 the act has come into force. Land Revenue Act has come into force in the year 1964 itself. So 65 ಅಲ್ಲಿ 16 acres grant ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಬರೋದಿಲ್ಲ. ಅಂದ್ರೆ it is a bogus entry. ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಮಾಡಿಲ್ಲ, ಪಾರ್ಟಿ ಇಲ್ಲ, ಮಾಡಿ.
ಮತ್ತೆ ವಾಟ್ ಇಸ್ ಯುವರ್ ಪ್ರೇಯರ್? ಅದೇ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಗ್ರಾಂಟ್. ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ? It is already granted in favor of some other person. How can it be granted once again to you?
Granted only 2 acres land. Mine is 16 acres land.
ಮತ್ತೆ ಗ್ರಾಂಟ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬರುತ್ತೆ? If your father has already been granted and out of that 16 acres only 2 acres and 35 guntas are granted in favor of another person, what is the prayer that you should have made? Either you should have challenged the subsequent grant made in favor of that person, so that person should be a party respondent here. So therefore that kind of a direction cannot be given. Learned counsel for the petitioner submits that the petitioner may be permitted to withdraw the writ petition and file a fresh writ petition on the same cause of action by giving more particulars and including necessary parties to the proceedings. Full stop. Next paragraph. Placing the submission of the petitioner, learned counsel for the petitioner on record, the petition is permitted to be withdrawn. The writ petition stands dismissed as withdrawn, while reserving liberty to the petitioner to file a fresh petition on the same cause of action, as stated herein above. Ordered accordingly.
respondent survey authority. If we reverse, based on the register table,
Advast. You filed online application.
59, 60, 61, 52 are the applications filed on online.
Page 51.
Page 59 in the server. 59 annexure J. 60K. Annexure L 61. 4 survey number. ಸರ್ವೆ ಮಾಡಕ್ ಬರ್ತಾರೆ.
23/8/2022.
ಫಸ್ಟ್ annexure J ಬಂದು 21
2 months time ಒಳಗಡೆ ಮಾಡ್ಬೇಕು.
22/10/2021 ಅಲ್ಲಿ ಹಾಕಿದ್ರು.
ಹಾ?
22/10/2021.
ಇಲ್ಲ. J.
annexure K ಬಂದು 26/22.
ಕೆಳಗಡೆ ಡೇಟು ನೋಡಿ ಅಲ್ಲಿ 8/23/2022 ಅಂತಿದೆ, ಅಂದ್ರೆ 23/8/2022. Annexure K is page number 16 ಅಂದ್ರಲ್ಲಿ. Annexure K
26/22. ಅರ್ಜಿ ದಿನಾಂಕ ಮೊದಲನೇದು. ಅರ್ಜಿ ಸಂಖ್ಯೆ.
Annexure J.
ಅರ್ಜಿ ದಿನಾಂಕ.
Annexure J. Annexure J ಆಯ್ತು. Annexure K
26/22.
ಅದೇನಾ ಮೇಲ್ಗಡೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೆಳಗಡೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅರ್ಜಿ ದಿನಾಂಕ ಮೇಲೆ.
ಕೆಳಗಡೆ ಏನ್ ಡೇಟ್ ಅದು?
ಕೆಳಗಡೆ ಇದು ಡೇಟ್ ಫಾರ್ ಫಿಕ್ಸಿಂಗ್ ದಿ ಬೌಂಡ್ರಿ. ಅವತ್ತು ಬರ್ತಾರೆ ಅಲ್ಲಿಗೆ. ಬಂದ್ಬಿಟ್ಟು ತಕರಾರು ಮಾಡಿರು ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಆಗ್ತಾರೆ. PDC annexure L 363. ಒಂದು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೇಳ್ತಾರೆ ಸರ್ವೇಯರ್. ನೆಕ್ಸ್ಟ್ ಒಂದು annexure ಒಂದು ಡ್ರಾ ಮಾಡ್ತಾರೆ. ಮಾಜರ್ ಡ್ರಾ ಮಾಡಿ
ಯಾರು ತಕರಾರು ಮಾಡ್ತಾರೆ?
ಪಕ್ಕದವ್ರು ನೈಬರ್ಸ್ ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಓನರ್. ನಾನು ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಆಗ್ತದೆ. They have to fix the boundary. Whether I am entitled or not is something I have to go to the court or something else. They will work out by remedy. Boundary fix ಮಾಡಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಹೋಗೋದು ತಪ್ಪು. They cannot refuse to fix the boundary. Where is the annexure P? ಚಿಕ್ಕಬಳ್ಳಾಪುರ ನಂದಿಯೋಡಿ ಬಾಗಿಲು ಮುಂಚಿತವಾಗಿ ನೋಟಿಸ್ ಮೂಲಕ ತಿಳುವಳಿಕೆ ದಿನಾಂಕ 27/22 ಅಳತೆ ಮಾಡಲು ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಬಾಜುದಾರರು ಜಗದೀಶ್ ಅಳತೆ ಕೆಲಸ ಪೂರೈಸಲು ಅಡ್ಡಿಪಡಿಸಿರುತ್ತಾರೆ. ನಂತರ ಸರ್ಕಾರಿ ಕೆಲಸವನ್ನು ಪೂರ್ಣಗೊಳಿಸಬೇಕೆಂಬ ಉದ್ದೇಶದಿಂದ ಮಾನ್ಯ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯ ನಿರ್ದೇಶಕರು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಅಳತೆ ಕೆಲಸ ಪೂರೈಸಲು ಪೊಲೀಸ್ ರಕ್ಷಣೆ ಕೇಳಿ ಮನವಿ ಮಾಡಿಕೊಂಡಂತೆ 29/7/22 ನಿಗದಿಪಡಿಸಿ ಅಳತೆ ಕೆಲಸ ಪೂರೈಸಲು ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಪುನಃ ಬಾಜುದಾರ ಅಳತೆಗೆ ಸಹಕರಿಸದೆ ಗಲಾಟೆ ಮಾಡಿರುತ್ತಾರೆ. ಪುನಃ ಹೆಚ್ಚುವರಿ ಪೊಲೀಸ್ ರಕ್ಷಣೆ ಒದಗಿಸಿ ದಿನಾಂಕ ನಿಗದಿಪಡಿಸಿ ನಂದಿ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಮೇಲಧಿಕ ಪತ್ರ ಬರಲಾಯಿತು. ಅನಂತರ 8/8/22 ಅಳತೆ ಮಾಡಲು ಸ್ಥಳಕ್ಕೆ ಭೂಮಾಲೀಕರು ಮತ್ತು ಸಿಬ್ಬಂದಿ ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಬಾಜುದಾರರು ಹಾಗೂ ಅವರ ಸಂಬಂಧಿಗಳು ಸೇರಿ ಅಳತೆ ಕೆಲಸ ಪೂರೈಸಲು ದೊಡ್ಡ ಮಟ್ಟದಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿರುತ್ತಾರೆ. ದೈಹಿಕವಾಗಿ ಹಲ್ಲೆಗಳಾಗಿ ಪ್ರಾಣಹಾನಿಗಳು ಆಗುವ ಸಂಬಂಧ ಕಂಡು ಬಂದರಿಂದ ಕಡತವನ್ನು ಅಳತೆ ಪೂರೈಸಲು ಕಷ್ಟಕರವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಇಡಲು ಈ ಕಡೆಗೆ ಸೇರಿದ್ದು ಸ್ವಾಮಿ.
ಸರಿ, ಅವ್ರನ್ನ ನಿಮ್ಮ ಯಾರು ಗಲಾಟೆ ಮಾಡಿದಾರ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದೀರಾ?
ಮಾಡಿ.
You will issue notice to them. Let them come and answer here. Why or for what reason they are objecting? On party ಮಾಡಿ. Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned HCGP. Since it is found that the neighbors are obstructing to the revenue officials in conducting the hadbast and fixing the boundary, it would become necessary for the petitioner to implead the neighbors who are causing obstruction. Stop. A week's time is granted to the petitioner to file necessary application to bring the neighbors on record. Yes. Restore ಆಗಿದೆಯಾ?
ತೋರಿಸಿಲ್ಲ. ಆತ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಐಎ ತೋರಿಸಿಲ್ಲ. To 9 to 10.
ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ ಕೊಡ್ರಿ.
ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿ
ತಗೊಂಡ್ರಿ, ಇದು ಫೈಲ್ ತಗೊಂಡ್ರಿ ಆ ಕಡೆಗೆ.
That's very good mistake. What is stated. The reason for filing that.
The objection.
Comply certain office objection. They have to comply certain office objection. That's why it was dismissed. If you last weeks were to see order dated 12/8/2021.
Non-complaints of office objections raised on IA number 1 of 2018.
18 ಮತ್ತೆ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂತಿದೆ. ಅವೆರಡು ಮಾಡಿಲ್ಲ ಅಂತ 4 days ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು. ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
What was that objection raised on IA number 1 of 2018?
ಎಲ್ಲ ಒಂದ್ರಲ್ಲಿ ನಾವು ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಬಂದ್ಬಿಟ್ಟು ಎಲ್ಲಾರ್ಸ್ನ ರೆಕಾರ್ಡ್ ತರಬೇಕಾಗಿತ್ತು. ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಯ್ತು ನಮ್ಗೆ, ಅವರು ತಂದಿಲ್ಲ ಅಂತ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ 2018 ಐಎದ್ರಲ್ಲಿ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನೋಡಿ.
ಚಿಕ್ಕ
27th August.
21 ಇದು 1 of 2018 ತೋರಿಸ್ತಾರೆ.
ಇದನ್ನ ಇವತ್ತು ಅಲೋ ಮಾಡಿದ್ರೆ ಈ ರೀಕಾಲಿಂಗು ಅದ್ರಲ್ಲಿ ಅವ್ರು ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗಲ್ಲ.
ಆಯ್ತು, what is that? I am trying to see. Usually it is only that copy is not served.
Please.
ಇದೇ objection.
ಅದು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್
that 1 of 2018 ನೋಡ್ರಿ. It was actually 1 of 2021 only. It is not 1 of 2018. Copy not served. Ashte copy served. ಇಲ್ಲ, ಬೇರೆ ಯಾವ್ದು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ. 2018 ಅಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ. 2021 ಅಲ್ವಾ? ಹೌದು. ಅವ್ರಿಗೆ ತೋರಿಸ್ಬಿಡಿ, ಇದನ್ನ ತೋರಿಸಿ ಅವ್ರಿಗೆ. ಅದೇ ತಾನೇ? So it should be 1 of 2021,
21,
not 18.
18,
And that copy is not served.
not served ಅನ್ನೋದು.
Serve ಮಾಡಿದ್ದೀರಾ ಈಗ?
ಇಲ್ಲ, ಇಲ್ಲ. ಅದು ಮಾಡಿಲ್ಲ. ಮಾಡಿಲ್ಲ. ಅದೇ ಅಬ್ಜೆಕ್ಟ್.
ಒಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ಅವ್ರು.
ಲೀಗಲ್ ಆದ್ಮೇಲೆ ಸರ್ವ್ ಮಾಡಿ. ಲೀಗಲ್ ಆದ್ಮೇಲೆ ಸರ್ವ್ ಮಾಡಿ.
Earlier, ಇದೇನಾ ಇದು? No. There was something called 1 of 2018. Now they have removed it probably.
We will verify it, madam.
Because 1 of 2021 is this application for recalling. ಅದಲ್ಲ. ಎಲ್ರಿ ಅದೇನು ತೆಗೆದು ಸೆಪರೇಟ್ ಆಗಿ ಇಟ್ಬಿಡ್ತಾರ? Even if it is yeah. I'll pass it over. You please verify, and if you find that 1 of 2018, you please Ikta. The deficit stamp. ಅಲ್ಲ ಅದು ಇದ್ರದ್ದು ಮೇನ್ ಪೆಟಿಷನ್. ಇದಕ್ಕೇನು ಸ್ಟ್ಯಾಂಪ್? ಐಎಗೆ ಇದಲ್ಲ ಇದು. Barley. Pending consideration of IA number 1 of 2021. Learned counsel for the petitioner is permitted to comply with the office objections raised on the writ petition as well as IA number 1 of 2018. Release this matter on 21st of September. ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಅದಕ್ಕೆ ಅಪ್ಲೈ ಮಾಡಿ, then we will recall them. If a copy is to be served, please serve a copy. Yes. Yes. ಕೊಡಿಲಿ. Your senior is not in station, is it? Huh? This writ petition also was dismissed for non-compliance. Way back in the year 2019. How can it be, madam? Even now they are showing that there is non-compliance. Following objections are yet to be complied. Typed copy of annexure H and K to be furnished. ಅದೊಂದು ಒಂದೇನಾ? Non-compliance of office objections. Annexure H and K. You have paid the costs? Huh?
7 out of them and 28 pay ಮಾಡಿದ್ದೀನಿ
Where is the acknowledgement? Order on year number 1 of 2019. This application is filed to recall the order dated 27/3/2019. On 27/3/2019, the petition was dismissed for on 27/3/2019, it was ordered that 2 weeks are granted to remove office objections, subject to payment of cost of rupees 250 payable to advocates, clerks, welfare fund within a period of 1 week. Stop. However, if steps are not taken and costs not paid, petition would stand dismissed without reference to court. Stop. Next para. Learned Counsel has furnished a copy of the receipt which shows that the cost of rupees 250 were paid on the very next day, that is 28/3/2019. Stop. However, in office objections not complied, the matter was treated to have been dismissed, but not complied. Treated to the office dated 27/3/2019. Stop. Next para. The counsel for the petitioner submits that all other office objections have been complied except furnishing typed copies of annexures H and K. Stop. The counsel submits that annexure H is a revenue sketch and a typed copy or better copy cannot be given. Annexure K is readable. Stop. Therefore, office objections are overruled. Stop. Next para. For the reason stated above, the order dated 27/3/2019 is hereby recalled. Next para. Then it HCGP is recalled the writ petition is restored to its original file. Next para. Learned HCGP is directed to take notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition on the learned HCGP. Stop. Is this matter for preliminary hearing on 21st of September. Yes.
My lord, I appear for the petitioner, my lord. 2 weeks time may be granted, my lord, to take substituted service, my lord. 4 times process fee is paid, my lord.
For respondent number
6, my lord.
6, sir.
Not a owner at all. Sixth owner is not a owner, sixth respondent is not a owner at all. And he has made a party.
So he is not a necessary party.
Not necessary party. Only he has made a party. Tribunal he has made a party. Separate tribunal party.
So ಅವ್ರು ಮಾಡ್ಲೇಬೇಕಾಗುತ್ತಲ್ಲ. Is there any interim order?
No, my
There is
lord.
no interim order. Then who is respondent number 6 according to you?
Owner would.
Is Sanjeev Shetty is not a owner of Atal Manor. He is third party. And he made the party, Madegowda made the party. Sanjeev Shetty has a party to the proceedings and party. Actually, I am the owner of the property. I purchased the land from the tenant after the completion of period. I am the owner of the property. I am not made a party before therefore I made appeal before the KAT. KAT is allowed.
3 to 5. You are the contesting respondent.
Yes.
Anyway, there is no interim order. Senate counsel for the petitioner submits that since notice has been taken more than 3 times to respondent number 6, and the respondent number 6 is evading service of notice, the petitioner would file an application seeking permission to take out notice through substituted service.
Oh, he is remain absent in the KAT also.
Plus, sorry, they feel that since he is a party to the proceedings, and if we don't serve notice, then it can be held against us, and but they want to file an application, take out paper publication. ಯಾರು ಪರಿಚಯ ಇದ್ರೆ ನೀವು ಪರಿಚಯ ಇದ್ರೆ ಇವ್ರದ್ದು ವಕಾಲತ್ ಹಾಕ್ಬಿಟ್ರೆ there is no difficulty. ಮಾಡ್ಲಿ ಬಿಡಿ, ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. A week's time is granted to do the needful.
Much obliged.
Yes.
One office objection with regards to the NOC. With regards to the NOC, my lord. There are 4 petitioners.
Signature of petitioner number 1 not forthcoming on wakalat.
What has happened is there are 4 petitioners. Petitioner number 2, 3, 4 has given NOC in my favor, which has been filed. Petitioner number 1 has not given. Petitioner number 1 is the mother of 2, 3, 4. She is aged 71 years, not keeping in good health. Finding it difficult to get her wakalat for the NOC. My lord, request that as far as petitioner 1 is concerned, she could be represented by the previous counsel. I'll represent for the 2, 3, 4 because the interests are aligned. Color figures started. 71 years, not keeping in good health. NOC
ಅಲ್ಲ, ಪವರ್ ಆಫ್ ಅಟರ್ನಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗ she only had given her LTM. ಅದಾದ 2, 3, 4 had given NOC in my favor. ಅವ್ರಿನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ. As far as petition 1 is concerned, let she be represented with the previous counsel. 2, 3, 4 ಗೆ
ಬರ್ಕೊಳ್ಳಿ. Objection is raised. Office objection is raised regarding the wakalat filed by learned counsel Shri Vikar Ahmad B. Stop. It is stated that the signature of petitioner number 1 is not found in the Wakala. Full stop. Learned counsel Shri Vikar Ahmad submits that since the first petitioner is aged about 70 years, 71, and is unable to affix her signature on the NOC Wakalat, the learned counsel may be permitted to appear on behalf of petitioners number 2 to 4, while learned counsel Shri Ananda K may continue to appear for petitioner number 1. Full stop. Next para. The submission is accepted and office is directed to show the name of learned counsel Shri Ananda K for petitioner number 1 and the name of learned counsel Shri Vikar Ahmad B for petitioners number 2 to 4. Yes. Joint memo has been. A joint memo dated 6/9/2022 has been filed by the learned counsel for petitioners as well as learned counsel for respondents number 5 to 10, private respondents number 5 to 10. Stop. The memo contains the signatures of all the petitioners as well as respondents number 5 to 10. Stop. Next para. Learned counsels for the petitioners and the contesting respondents number 5 to 10 submit that the writ petition may be disposed of in terms of the joint memo. Stop. Next para. Accordingly, the writ petition stands disposed of in terms of the joint memo dated 6/9/2022, which shows the entitlement of each of the parties. Full stop. Next para. The writ petition is disposed of accordingly, in terms of the joint memo. Yes.
For respondent number 8 to 12, the first writ petition, and for petitioners in the second writ petition.
Yes. Is this matter after service of notice on response number 4 and 7?
Small submission. Respondent number 4 and 5, 6 belong to same family member. Writ petition is ready as against respondent number 5 and 6. And respondent number 7 was only a GP holder. At the time when father of the
if you want to take notice for respondent number 4, you please take. If you are saying he belongs to the same family as respondent number 5 and 6, then you can take notice.
Let them take.
Huh?
Let them only take.
Yes. No, they have already taken notice. Notice is awaited.
Where this interim relief was granted in the year 2020, after
Sir, they have already taken notice. The notice is yet to be received. Whether they receive it or not, we will come to know only after the postal cover comes back. Yes.
Date, my lord, for
for this matter.
No, no, we have said list this matter after service of notice. Yes. Yes. 27/2021. ಏನ್ ಮಾಡೋದು ನೀವು ಅಲ್ಲೂ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಇಲ್ಲೂ ಬರ್ಲಿಲ್ಲ. ಯಾರು PR ಪ್ರಭುಲಿಂಗ ಮೂರ್ತಿ? ಯಾರು ನೀವೇ ತಾನೆ? Order year number 1 of 2021. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ ಅದ್ಮೇಲೆ ಆಫೀಸರ್ ಮಾಡಿಲ್ಲ ಅಂತನಾ? Copy to be served on AGA. ಆಯ್ತು, ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. Counsel for the petitioner. They served a copy of IN number 1 of 2021 on the learned HCGP. ಇವಾಗಲೇ ಕೊಡ್ಬೇಕು ನೀವು ಮಧ್ಯಾಹ್ನ. Order on IN number 1 of 2021. This writ petition was dismissed by order dated 20th of July 2021, having found that there was no representation for the petitioner on 15/4/2021 and on 20th of July 2021. Stop. Learned counsel for the petitioner submits that the learned counsel was unwell and therefore he was not able to attend to the proceedings on both the days. Stop. Nevertheless, having regard to the prayer made in the writ petition, this court is of the considered opinion that the order dated 20th of July 2021 may be recalled by imposing costs. Stop. Next para. Accordingly, order dated 20th of July 2021 is recalled by imposing costs of rupees 1,000 on the petitioner payable to note within a period of 1 week from today. Full stop. The writ petition is restored to its original file. Full stop. Next para. Release this matter for preliminary hearing on 21st of September 2022. Full stop. The acknowledgement for having paid the costs shall be furnished in the office before the next date of hearing. Yes.
ಅದಕ್ಕೆ ನಾನು ಕೂತಲ್ಲಿ ಬಂದು ರೀಚ್ ಆಗುತ್ತೆ ಹೆಂಗೆ ಅಲ್ಲ ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡ್ಬಿಡ್ತೀನಿ
ಕರ್ನಾಟಕ
ಸ್ವಲ್ಪ ಇದು ಚೇಂಜ್ ಆಗಿದೆ ಲಿಸ್ಟ್ ಈಗ ಫೈನಲ್ ಇಯರಿಂಗ್ ಫಸ್ಟ್ ಬಂದು ಆಮೇಲೆ ನೋಡೋಣ ಇವತ್ತು ಹೌದು 230 ಸ್ಮಾಲ್ ಲಿಸ್ಟ್ ಇದೆಯಾ ಆಮೇಲೆ ಆ ಬಿಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ 230 ಬಂದಿದೆ ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನೋಡೋಣ ಇವತ್ತು ನೀನು ವೆಕೇಶನ್ ಆಗೋದು ಸಿಟ್ಟಿಂಗ್ ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ 30 ಈಗ ತಾರೀಕು ಆದ್ಮೇಲೆ ಸರ್ 10 ಆದ್ಮೇಲೆ 10 30 ಲಾಸ್ಟ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ವೆಕೇಶನ್ 1ನೇ ತಾರೀಕು ಶನಿವಾರ. ಮಾಡಕ್ ಹೋಗಿಲ್ಲ, ಆಫೀಸ್ ನಲ್ಲಿ ಹೋಗಿ ಕೇಳಕ್ ಹೋಗಿಲ್ಲ. ಯಾರು ಸರ್ ಆಫೀಸ್ ಇದು ಗೌರ್ಮೆಂಟ್ ಯಾವ ಇಯರ್ ಇದೆ? 17, ನಮ್ದು 17. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ಬೋದು ಅದು. ಅದು ತಿರ್ಗಾ ರೀಚ್ ಆಗ್ಬೇಕಲ್ಲ ಹಾಕಿದ್ಮೇಲೆ. ಗೌರ್ಮೆಂಟ್ ಅವ್ರು ಒಂದು 50-60 ಮೀಟರ್ ಓಲ್ಡ್ ಮೀಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ರೆಡಿ ಆಗ್ರಿ ಅಂತ. ಯಾಕಂದ್ರೆ ಬಂದಾಗ ಟೈಮ್ ಕೇಳಕ್ ಬೇಡ ಅಂತ. ನಮ್ದು 17 2 ಮೀಟರ್ ಇದೆ, 21, 22 2 ಇದೆ. ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ 4 ಕನೆಕ್ಟೆಡ್ ಇದೆ. ನೋಡೋಣ, ಇವತ್ತು ನಾಳೆ ನೋಡ್ತೀನಿ. ಆಮೇಲೆ ಬರೋ ವಾರದಲ್ಲಿ ಏನಾನ ನೀವು ಕೊಟ್ರೆ, ನೀವು ಕೊಟ್ಟಿರೋ ಲಿಸ್ಟ್ ಬಂದ್ರೆ ಅದು ಹೇಳ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತದೆ.
ರಿಜೆಕ್ಟ್ ಅಂತ ರಿಜೆಕ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ಬಿಟ್ಟಿದೆ.
46, my lord.
But who is on the other side?
Let's I pay for the respondent number 3. Instead of tomorrow, it may be called on Friday or Monday, my lords. Tomorrow, too many part-heard matters are there. Date given.
Monday.
Serial number 46. At the request of learned counsel for petitioner. Release this matter on 21st of September.
Serial number 52. The other side is the government.
Huh?
The other side is government.
Huh? Huh?
Next.
You are appearing for the. What is the difficulty? Serial number 52. At the request of learned counsel for petitioner, release this matter next week. Interim order granted earlier stands extended to the next date.
Number 13.
Who's on the other side? Why do you want to ask for adjournment? Huh? Earlier also you had sought for adjournment. Huh? Review petition file ಮಾಡಿರೋದು 2019. ಇಲ್ಲಿವರೆಗೂ ನೀವು ರೆಡಿ ಆಗಿಲ್ಲ. I understand what you are doing. ಏನ್ರಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ರಿ ಇಲ್ಲಿ. At the request of learned counsel for petitioner, release this matter next week. Yes.
Number 29.
Short for mandamus was considered an endorsement. Learned counsel for petitioners has filed a memo dated 7/9/2022. Stating that the respondent has issued an endorsement dated 27/5/2022. After the writ petition was filed. Stop. Therefore, the petitioner is now required to raise a challenge to the endorsement. Stop. Therefore, it is prayed that the petitioner may be permitted to withdraw the writ petition. Liberty to challenge the endorsement dated 27/5/2022. Stop. Next para. Accordingly, the petition stands dismissed as withdrawn, with liberty reserved to the petitioner to raise a challenge to the endorsement dated 27/5/2022.
Judgment petitioner number 1 grammatically mistake ಆಗಿದೆ. GR ಆಗಬೇಕಾಗಿದೆ JR ಆಗಿದೆ.
ಏನೋ
GR ಆಗಬೇಕಾಗಿತ್ತು ಮೇಲೆ ಅದು JR ಆಗಿದೆ.
correction of order.
Judgmental.
When did you correct this in the cost title?
आप ही subjection है.
Huh?
आप ही subjection है.
Order. Huh? No, but I do not know how, in spite of the cost title being corrected,
Yes.
this writ petition was disposed of. Order on IA number 2 of 2022. This writ petition was disposed of by order dated 11th of August 2022. So, however, this application is filed seeking correction of the initials of petitioner number 1, which is shown as J.R. Ishwarappa instead of G.R. Ishwarappa. Full stop. Next para. The sufficiency of the learned counsel for petitioner is accepted. IA number 2 of 2021 is allowed, while directing the correction to be carried out in the cost title. Full stop. Office is directed to correct the cost title accordingly and issue a fresh certified copy to the petitioners.
Gujarat seat. 2 weeks time for applying the office objection, because when I went, the file was not available. Hence, I moved.
Finally, 2 weeks are granted at the request of learned counsel for petitioner for compliance of office objections.
For
the respondent 4 and 5.
I've done the needful in respect of issue of notice to respondent number 8.
When learned counsel for the petitioner submits that steps have been taken for service of notice on respond number 8, this morning, full stop, office to verify and issue notice. Yes. Interim order granted earlier stands extended to the next date of hearing.
Time may be granted.
Huh?
Time may be granted.
A week's time is granted at the request of learned counsel for petitioner for compliance of office objection.
Actually, photocopy I have produced. Now the copy is ready. I will comply with the order. I will comply with the office objection. One Srinivas Iyengar was the owner of survey number 68 in respect of 1 acre 24 guntas. And another survey number 63/1 in respect of 20 guntas. So far as 31 guntas in survey number 68 is concerned, there was a tenancy dispute. Landlord was conceded, that is predecessor of these petitioners. So far as 31 guntas are concerned, and occupancy rate was granted in favor of the third respondent forefather. And remaining extent 33 guntas out of 1 acre 24 guntas. The petitioner went before the revenue authorities to correct the mutation in respect of remaining extent out of 31 guntas, which was conceded in favor of the third respondent predecessor. But it has not been done. The third respondent, what it did was, he filed an appeal challenging the mutation register in favor of the predecessor of my father. In the year of 2019, my Srinivas Iyengar, original owner, was died in the year of 1978. Making him as a party, Mr. J came to be passed. So far as 31 guntas is concerned, it is covered out 1 acre, out of 1 acre 24 guntas.
and actually it is my lord against the dead person. Number two, my lord, he is misrepresenting one more. My lord, Srinivas Iyengar was owner of another.
When did you purchase the land? When did you purchase the land?
It is an ancestral property, my lord. My lord, I have produced the annexures, my lord, in annexure A may kindly see, my lord, from 1968. Lord, C. Srinivas Iyengar, my lord, was the original owner in respect of 1 acre 24 guntas. Lord, annexure P7 may kindly see. It is the page number 50. It is the register extract, demand register extract. In it, my lord, item number 68. 1 acre 24 guntas, my lord, Sri Srinivas Iyengar is the one. It is the demand register extract. Lord, up to, my lord, up to till today, Srinivas Iyengar name is going on. But the Srinivas Iyengar, my lord, was the owner in respect of other survey number, my lord, that is 63/1 in respect of 20 guntas. My lord, after passing this, getting this order, my lord, 2019 against the dead person, my lord, one more representation has been made by the third respondent, my lord, saying that I have granted 20 guntas in respect of 63/1 also. Therefore, the revenue entries has to be mutated in my name. Now, my lord, annexure M, I am challenging. But is granted or mechanically, my lord, I have produced. Only is, my lord, page number 17 mechanically see. The grant in favor of the third respondent father in respect of, my lord, survey number 143. Extent is 20 guntas. The page number 17 mechanically see.
Mr. Srinivas
Iyengar.
approached the assistant commissioner
Yes, please.
in the year 2017.
Yes.
Huh?
No, in the year of 2008 itself, there was a recommendation. There was a recommendation by the assistant commissioner saying that the out of 1 acre 24 guntas, remaining acre 33 guntas, the mutation has to be changed in the name of Srinivas Iyengar. That was the observations made on the earlier occasion in the year of 2010. Page number 56.
56.
Paragraph, page number 57.
Annexure D.
Page number.
That is a communication.
Yes, it is a communication. In this communication, what they are correspondence is remaining 1 acre out of 1 acre 24 guntas, 31 guntas is considered in respect of tenancy. Therefore, remaining action 33 guntas it has to be put in the name of Srinivas Iyengar. But it matters to this, the annexure J is passed now.
J.
J.
Page number?
Page number 77. In which, the respondent number 2 is the landowner, the Srinivas Iyengar. Virtually, he is no more. He died in the year of 1978 itself. I produced the death certificate also. Annexure G, page 69. Operative portion may kindly see, page number 80. The respondent number 1, Tahsildar Bengaluru North Additional Taluk is hereby directed to effect the mutation in the name of the appellant in respect of 20 guntas out of 33 guntas, which stand in the name of respondent number 2 in respect of survey number 68 situated in Kattiganahalli Jala.
ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು?
ಇದು ಫೈಲ್ ಮಾಡಿರೋದು ಇವರು ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾದಪಿಲ್ಲಪ್ಪ. He was the son of the grantee, original grantee.
Madapillappa.
Madapillappa.
He is not in the.
He is no.
He is no more.
He is no more. But his grant, my lord, I have shown your lordship grant certificate, my lord. He was the grantee. Third respondent is the son of original grantee. He initiated this proceeding.
He filed against Srinivas Iyengar,
Against Srinivas Iyengar,
knowing fully well that he was not alive.
He was no more.
Ah.
I produced the death certificate, my lord, annexed G page 69.
When did he pass away?
1978.
ಆಯ್ತು.
Now, my lord, so far as my lord survey number 68 is concerned, my lord.
ಸರಿ, ನಿಮ್ಗೆ ಯಾವಾಗ ಗೊತ್ತಾಯ್ತಿದ್ದು?
Immediately. Immediately.
ಏನ್ ಮಾಡಿದ್ರಿ?
Now we are challenging. One more order is passed, my lord. Now, one more order is passed. So far as another extent is concerned, my lord, the Srinivas Iyengar, my lord, was the owner of 2 survey numbers. One is, my lord, 1 acre 24 guntas.
That order was passed by the assistant commissioner.
Yes.
You could have gone before the deputy commissioner.
No, by that time, my lord, another order has already been. No, it is, my lord, virtually it is against the dead person.
ಆಯ್ತು.
Now, my lord, annexure M, page number 87, may kindly see. This is one more proceedings have been initiated at the instant of third respondent, saying that, my lord, he is already aware, my lord, his land is already granted and it is his name is entered in the revenue entries. But he is misrepresenting, my lord, saying that survey number 63/1, it is also granted in favor of my father. Therefore, the revenue interest has to be mutated in favor of the third respondent. Which, my lord, we have not the legal representatives are not made as a parties. Page number, my lord, 90, operative portion, may kindly see. The above appeal is appellant is hereby allowed. The impugned endorsement dated 30th 10/2007 is issued by respondent number bearing number 143, new survey number 63/1, measuring 20 guntas with 39 village set aside. Further, respondent number 1, Tahsildar Yelanka Taluk Yelanka is directed to mutate the Kata and RTC in the name of the appellant and Srinivas related Mata Pillappa, grandson of Chikka Abbayappa, in respect of the land survey number 143, survey number 63/1, measuring 20 guntas in Katiyanalli, Jalavabli, Bengaluru, Karnataka. So therefore, my lord, he has availed the land in 2 bits, my lord. Only one grant in respect of 20 guntas, but my lord, he has availed 20 guntas and another 20 guntas in respect of 2 survey numbers.
Sari, ಆಯ್ತು. This is also an order passed by the assistant commissioner under
and in which, my lord, we are not
136(2). Yes. Yes.
Therefore, my lord, it is out of jurisdiction. This order is, my lord, out of jurisdiction.
Without jurisdiction.
Without jurisdiction.
Why do you say it without jurisdiction?
My lord, originally, my lord, the landowners
without jurisdiction, Allah. You may say they have played a fraud without impleading you.
Yes.
They have obtained an order at the hands of the assistant commissioner.
Yes.
You can't say it is. Even that can be canvassed before the deputy commissioner. There is already an order.
Yes, there is already an order. And, my lord, pursuant to that, my lord, he has already got the mutation entry and he has transferred the land in favor of third person.
ಸರಿ, ಇವಾಗ ಮತ್ತೆ ಇವಾಗ ಏನ್ ಮಾಡೋದು ಮತ್ತೆ?
We have made them as also.
What is the use of?
We have made them as also party in this proceedings. Srimati Manjula.
Learned AGA. Learned HCGP is directed to take notice for response number 1 and 2. Issue emergent notice to response number 3 and 5. Returnable by 28th of September 2022. Learned counsel for the petitioner is directed to serve a copy of the petition on the learned NCD. Yes. Next para. In the meanwhile, office objection shall be complied with. Interim order. You are saying that the land is already transferred. Ivaga ಏನು interim order? Yes.
35. Heavy Ramar.
Current endorsement issued by the first respondent law. You are saying that not my application for regularization of the land.
Non-filing of acknowledgement. You said a copy on the,
Okay.
huh?
Yes, Lord. Certain. What is it? I'll give it now.
What is ಅದಕ್ಕೆ ಬಂದಿರೋದು ಇವತ್ತು? ಹಾ. It's already come up for preliminary hearing once. Then what are you submitting now?
First time it comes.
Learned counsel for, no. It's already come. I have directed notice. Learned counsel for the petitioner is directed to serve a copy of the writ petition on the learned HCGP. Yes. It is matter of the service of notice on respond number 5. After service of notice, it will be listed. Ah.
7.1 law. Amendment or kindly that memo for trial. Amendment or kindly see that memo for trial. Find the memo for trial. We are seeking permission of this court to withdraw that writ petition. 37.1.
Please serve a copy of the writ petition in the other matters.
Already noticed
Actually, I have pointed out that of the same cause of action by the same party.
Yes.
I filed for moment of kindly see that memo for trial sound. Memo for trial. Sound sorry.
ಹೇಳಿ.
ಅಲ್ಲ memo for trial.
ನೋಡ್ತಾ ಇದೀನಿ ಹೇಳ್ರಿ.
Totally why the second petition was filed ಅಂತ ಹೇಳಿ
ಹೇಳಿ ಓದಿ.
Not that that the undersigned counsel appearing on behalf of the petitioner most to submit that in the above petition there was a typographical error in respect of the survey number 24 measuring 24 untas instead of mentioning the measurement as a 20 untas as per the compromise. In fact, that the undersigned counsel instructed the typist to prepare the fresh petition, which is filed to seek the relief of madam to mention about the pending of the above petition at para number so and so. But
the undersigned counsel instructed the typist
prepare model getting. That is the outcome not that because of this mistake not I am seeking for that. Also kindly see that compromise petition law. The measurement is 24 guntas anta agide, but actually the allotment 65. Page number 65. That actually 20 guntas not. Matte there is complication agutte anta helane. That actually even that earlier petition allu 24 anta agide. Nanage actually
ಇನ್ನೊಂದು writ petition ಕೊಡಿ.
But page number 20 law. Page number 20 in the writ petition. The entire body of the writ petition law. That is the typographical error.
What did we discuss yesterday?
Because on the same cause of action. Earlier he has filed a writ petition. Without disclosing my lord say.
On the merits of the matter.
Merits of the matter. My lord wanted to know. In RTC it is shown as my lord based on this compromise only. In respect of his brothers, RTC is entered. It was long back, my lords. Whether they Vivagan Madidero ಅಥವಾ ಇಲ್ಲ ಅಂತ ವಿಚಾರಿಸಂತ. Your present Tahsildar was not there at that time. But RTC shows that it is based on that partition only. And there is one objection. You will consider that objection also, my lords, act on that. And one more submission, my lords, he has not made available this judgment or whatever he relies. Only in representation is submitted. Copies.
Kindly see.
ಇಲ್ಲಿ ಆಯ್ತು ಅಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಹತ್ರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅದಾದ್ಮೇಲೆ ತಾವು ಪೇಜ್ annexure page 19 ನೋಡಿ kindly see the
ಇಲ್ಲಿ ಅಲ್ರಿ ಅವ್ರು ಹೇಳ್ತಾರದು ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸುಮ್ಮನೆ ಕೊಟ್ಟಾದ್ಮೇಲೆ that what are the documents there I enclose the documents not page 91 ಅಲ್ಲಿ ಇದೆ ಸುಮ್ಮನೆ ಅದು ತಗೊಂಡಾದ್ಮೇಲೆ they given the assignment for that. That is my response submission. Okay, annexure page 19 law. Otherwise, once again, if this go direct, I will publish all the documents. Annexure page 90. Actually, 91 ನೋಡಿ page 91.
ಇಲ್ಲಿ ಕೊಡೋದಲ್ರಿ ಅವ್ರು ಕೊಡಬೇಕು.
ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ ಕೊಟ್ಟಿದ್ರೆ assignment ತಗೊಂಡಿರೋದು my submission.
ತಗೊಳ್ಳಿ ಸಾಹೇಬ್.
Annexure
ಏನ್ ಮಾಡಿದಾರೆ?
Annexure H ಅಲ್ಲಿ page 90 91 ಅಲ್ಲಿ ನಾನು ಏನೇನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ list of documents have furnished. ನನಗಿದ್ರಲ್ಲೇನೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ
ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಪೇಜ್ 91 ರಾಜಿಯಾಗಿರುವ ಪ್ರತಿ ಡಿಗ್ರಿ ಶೆಡ್ಯೂಲ್ 5 ಅಬ್ದುಲ್ ಅಜೀಜ್ ಅವರ
ಇಲ್ಲಿದೆ ಡಿಗ್ರಿ, ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಡಿಗ್ರಿ. ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲ ಕೋರ್ಟ್ ದಲ್ಲಿ ಕೂಡ ಡಿಗ್ರಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಕೈಂಡ್ಲಿ ಸಿ ಇಟ್ ಇಸ್ ನಾಟ್ ದ ಡಿಗ್ರಿ ವಾಟ್ ಹಿ ಹಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ಇಸ್ ಓನ್ಲಿ an order of the court. I also wanted to know from him whether degree is drawn.
There is no degree.
ಅದು ಡಿಗ್ರಿ ಕೊಟ್ಟೇ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಬರ್ಕೊಳ್ತಾರೆ. ಇಲ್ಲಿ ತೋರಿಸಲಿ ಡಿಗ್ರಿ.
Because for in the case of preliminary degree the partition suit, if the parties are compromising that whatever the compromise petition ಅಲ್ಲಿ ಏನ್ ಬರುತ್ತೆ ಅದೇ ಬರುತ್ತೆ.
ಸರ್ ಅದು ಡಿಗ್ರಿ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ನೀವು ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಬರ್ಕೊಂಡು ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಹಂಗ್ ಬಿಟ್ಬಿಟ್ರೆ ಏನಾಗುತ್ತೆ?
Is it a degree passed by the court
ಸಾಹೇಬ್ರ
which can be implemented in terms of
section 130?
ಅಲ್ಲ ಅಲ್ಲಿ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಡಿಗ್ರಿ ಅಂತ ಬರ್ಕೊಳ್ತಾರೆ.
ಐಡೆಂಟಿಕಲ್ ಕೇಸ್ ನಾಟ್ ಇಟ್ಸ್ ದಿ ಕೋಆರ್ಡಿನೇಟ್ ಬ್ರಾಂಚ್ ಆಫ್ ದಿ ಸ್ಯಾಂಬಲ್ ಕೋರ್ಟ್ ಇದೇ ತರದ ಇದ್ರಲ್ಲೇನೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಏನಂತ?
ಇದೇ ಈ ತರ ಇದ್ದಾಗ ಕೈಲಿಸಿ
ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಇದ್ರೆ ಸಾಕು.
ಇಲ್ಲ ಅದಲ್ಲ. ಸೊ ಈ ತರ the parties have been acted upon the preliminary degree in respect of the changing of revenue record. For kindly see page identical case in the coordinate bench. Page 3 nalli.
Even without seeing that, I have asked the learned counsel.
Degree ಇಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ಡಿಗ್ರಿ
ಇಲ್ಲ furnish the
ನೀವು
document.
ಮಾಡೋದಲ್ಲ ಏನೇನೋ ಮಾಡ್ತೀರಾ.
ಅಲ್ಲ ಮತ್ತೆ ಈಗ ಅದರ ಮೇಲೆ relevant documents are ಏನ್ I am ready to furnish them.
What will you furnish? There is no decree to be furnished. Admittedly, there is no decree.
ನನ್ನ
Then
ಹತ್ರ
how are you saying that I will furnish? I will furnish.
ಅಲ್ಲ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
ಈಗ ಅವ್ರು ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ವಾಟ್ ಆರ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಐ ಆಮ್ ಹ್ಯಾವಿಂಗ್ ಐ ವಿಲ್ ಫರ್ನಿಶ್ ದೋಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
It didn't matter. Let's permit him to withdraw. So that
37.1 ನಲ್ಲಿ the petitioner and learned counsel for petitioner have filed a memo dated 13/9/2022 stating that the petition WP 2079 of 2022. However, although instructions were given to the typist to mention that the petitioner has filed this writ petition, by inadvertence, the same was not mentioned. Stuff. Learned counsel has tendered unconditional apology and seeks leave of this court to permit the petitioner to withdraw the writ petition. Full stop. Next para. Although this court is not satisfied with the explanation sought to be offered, nevertheless, placing on record the unconditional apology tendered by the learned counsel for petitioner, the writ petition stands dismissed as withdrawn. So, ಇನ್ನೊಂದು matter ಅಲ್ಲಿ the prayer in the writ petition is to issue a writ of mandamus directing the respondent authorities to consider the representations given by the petitioner to effect mutation and enter the name of the petitioner in the land revenue records. In respect of three items of property which are mentioned in the representation, which according to the petitioner have fallen to his share in terms of the compromise petition filed before the
Civil Judge Tumkur, invoice number 68 of 1970.
Civil Judge
Tumkur.
Junior Division, Junior Division, Tumkur, invoice number
68 of 1977.
Stop. Next para. On going through the material available on record, it is found that although the petitioner has not placed the compromise decree passed by the civil court, nevertheless, it is clear that the revenue authorities have acted upon the compromise petition said to have been filed by the parties before the civil court. Stop. Tapping the position, when the names of the other parties have been entered in the land records in terms of the compromise petition, there was no reason for the respondent Tahsildar, Tumkur Taluk, not to accede to the request made by the petitioner. Stop. Next para. Consequently,
Objection also. One objection is filed for that. Then let him also.
Consequently, the writ petition stands disposed of with a specific direction to the fourth respondent Tahsildar, Tumkur Taluk, to consider the representations given by the petitioner and having regard to the fact that mutation entries have been effected in the land records in favor of the other parties who acquired share in the lands in question by virtue of the compromise petition, and while considering the objections filed by any party, the Tahsildar shall proceed to pass necessary orders as expeditiously as possible, and at any rate within a period of 2 months from the date of receipt of a copy of this order. Stop. Ordered accordingly. Great. List this matter after service of notice on response number 4 to 21. Entry order granted arrears and extended till the next date of hearing. Sorry.
This was not the order of the assistant commissioner in appeal
Where my lord, without assigning reasons, my lord, the interim order that is granted against the order of Tehsildar for demolition, my lord, okay. The Tehsildar had not initially initiated proceedings, saying that there is enforcement of the government land on the basis of direction from the Supreme Court in respect of survey number 1/3 and 1/5 of Chalasandra village.
Where are those orders?
That lot is at page 56 lot is the order of the Supreme Court. Page 56. Short events of the petitioners against non-consideration of the request for carrying out before that not this request not look at the right at the top, not at page 50. So not what was under challenge. Sorry, 57. The same petition is filed under Article 226 of the Constitution of India, aims to direct the respondent hearing to carry out a survey measurement for the lands in survey number 1/3 and 1/5. Chalasandra village, the new South. Short events of the petition is against non-consideration of the request for carrying out survey and measurement for the subject land. So also she believes that a request for removal of alleged encroachment of public road has not been considered. The AG appearing for the original respondent submits that the said exercise will be undertaken and accomplished within a period of 4 months. This is fair enough. In view of the above, writ petition is disposed of, placing the undertaking of the respondent on record. Second respondent, Deputy Commissioner, is directed to consider and cause survey and measurement of the subject land, and consequent upon such exercise, if any enforcement is noticed, appropriate action shall be taken for its removal in accordance with law. Type of completion is for compliance is 4 months from date. Copy of this order is produced, dealing with second respondent Deputy Commissioner will personally pay a cost of rupees 2,000 per day to the petitioner. Not pursuant to this, there is a notice issued not at page 28.
You had made a complaint.
I had not.
The second sentence in the first paragraph. So also she grieves that her request for a removal of alleged encroachment of public road has not been considered, which means you also had made a complaint.
I am not a party to this writ at all. I am not a party to this writ. This writ is not filed by somebody else, saying that some representation being not considered. Also, there is encroachment. Please remove one car. Pursuant to that,
so probably she has made a complaint against you.
I am not a party to this.
All right.
She says there is encroachment of this 1/5.
Yes.
So thereafter, notice is issued at page 28 by the Tehsildar. Issued notes on 11 to 22. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರಳ್ಳಿ ಹೋಬಳಿ ಚನ್ನಸಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 1/3 ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 1/5 ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವುದು ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರಂತೆ ಈ ಕಚೇರಿಗೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 7 ದಿನದೊಳಗಾಗಿ ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸಲು ಸೂಚಿಸಿದೆ. Pursuant to this, I respond. My replies are at page 59, where I say I am not on 1/3 or 1/5. There are not several persons whom the notice is issued. I will not say that I have been allotted certain sites pursuant to housing society.
Srimati Maitri.
That is not the first petition, is that annexure G1, that is at page 59. Notice ಅಲ್ಲಿ ಬರೀ ನಂಬರ್ ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ.
ಮನೆ ನಂಬರ್.
So I respond to that, saying that my site is not under survey number 1/3 or 1/5, and in fact, I am under survey number 90, which you find at page 62. I have said that this particular site that I have been allotted. And I have been there since 2006. And I have also not stated that the survey that is allegedly been carried out is not been noticed to me without behind my back. All of that. Now, pursuant to and there are several mallards of these representations because several persons notices have been issued. Pursuant to that, the Tehsildar passes an order at page 35. But the operative portion and the reasons will not start from page 42.
This is under section 104.
This is under 104.
Encroachment of Sarkari Oni between survey number 1/3 and 1/5.
Page 42, third argument. All my arguments are okay, and my lords, page 42 is the reasons.
So you were heard.
I was heard.
You were heard.
I was heard. My only thing is that as far as that survey, my lords, that will not be relies on. That will not copy. I was not present for the survey. But heard the arguments, peruse records. By perusing the material documents available in record, it shows that the respondents are claiming their rights over different sites formed in survey numbers 19/3, survey number 8/2, new survey number 8/2A, and they are contending that they have nothing to do with the survey number 1/3 and 1/5, Channasandra village. However, it is not in dispute that the above proceedings has been initiated pursuant to directions of the Honorable High Court of Karnataka in writ petition number 14254 of 2018 dated 37/2021 for identifying the encroachment of the Sarkari Oni.
So what are your grounds?
Pursuant to this, I, my lords, filed not an appeal before the Assistant Commissioner. On the first date of hearing, there was not the same lords of this order that was not granted. Now, thereafter, it is not vacated without any reasons. I am not relieved by that because my appeal will not still not remain before the Assistant Commissioner. That lords will find at page 30 lords. The order sheet. Right at the bottom, lords. The
appeal is filed under which provision?
This is under 49, lords. 49. Because this thing says 136(2). No. The mailed and order 136(2) will be there. Okay. Under 49, special and there is nothing to the there is also not end appeal. In fact, I will not come to that also.
No, there's a very pregnant reason in me asking you what are the grounds that you have raised. If you have gone through section 104 carefully.
That is, I don't know if I should bring that up because it's on board because strictly on merits, it's pending there. But on 104, yes, strictly not 104 Parala because there are only not 3 grounds that are enumerated under 104, and encroachment is strictly not one of them. It is not for a violation of a condition under 98. That is not condition of any other.
It is only under section 67.
67.
That the deputy commissioner is empowered to take action. You have not raised all those grounds.
Not because my only difficulty is not my appeal is today pending before the Assistant Commissioner.
Berkeley. Learned AGA takes notice for. Learned HCGP takes notice for all the respondents. Learned counsel for the petitioner is direct to serve a copy of the petition on the learned HCGP. Next para. The grievance of the immediate grievance of the petitioners is that when the Tahsildar, Bangalore South Taluk, passed an order dated 22nd of April 2022 in a dispute number NCR bracket U close CR 8/2015-16 and the petitioners approached the Assistant Commissioner challenging the order of the Tahsildar, although an interim order of stay was granted by the Assistant Commissioner by order dated
26/7/22. 651.
26/7. Allah.
28/6/22. Page 13 ali.
26.
26.
26/2022. Mailgade there. Date and time. 26/2022. 26. Come on, nevertheless, without any reason, the interim order of stay was vacated on 2/9/2022. Stop. The order dated 2/9/2022 passed by the assistant commissioner reads as follows. Extract ಮಾಡ್ಕೊಂಬಿಡಿ page number 34 ಅಲ್ಲಿ ಇದೆ. Learned Council submits that such an order would not have been passed by the assistant commissioner without giving an opportunity of hearing to the petitioners. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 2/9/2022 passed by the assistant commissioner, Bangalore South Taluk in RA bracket A 301 of 2022, till the next date of hearing. Next para. A week's time is granted for complaints of office objections. Please comply with the office objections.
Number 55, page number 8.
I appear.
On behalf of Learned Council, Shri
Yes.
Hubli.
Yes. There's one aspect that I want to point out.
Sir, I have taken already 3 or 4 days.
I know it was.
And it is not fair on the part of the Learned Council to have brought you now at this stage. I had told him I'll give you only 15 minutes to give a reply. It's all right. All submissions have been made by 2 learned senior counsels on the merits of the matter. The only allegation that his clients have to meet is that it has been pointed out by the learned counsel for the respondents that he is a subsequent purchaser, a purchaser who has purchased the land as a on the 3rd occasion. His predecessors had already filed an application in form number 5 under section 5. They had got their applications dismissed. Their applications were dismissed. Thereafter, these people also go and file another application. So he has pointed out that they had no locus standi to first of all file the application. So to that extent, if you make submissions, I will hear regarding the merits of the matter, that it was a Gomal land or not. Submissions have been made for 3 or 4 days.
One division bench judgment that I want to place for your lordship on Goman. And there is one single disorder that I want to place. What is the nature of a Goman land? Not division bench of this court had occasion to. So can I point out that first and
Yes.
then read the other point? Now kindly turn to page number 10 of this memo.
Yes.
I just read the relevant portions not and leave it at that. Petitioners have filed public interest litigation, public interest petition, assailing the grant of Bhuman land in survey number 26 and 27 of so village in favor of respondent number 3 and 4. By the impugned orders, Special Deputy Commissioner has granted an extra 60 days and 23 guntas in the third respondent. While the fourth respondent has been granted an extent measuring 20 acres. So, not a grant of a Goma land was thought to be challenged. The question is very clear before the board was as to whether it was Goma land. Now, can you see how the division made? Division made up to this point. May I request you kindly turn to paragraph number 6 at page 14. Though the respondents are questioned, the locus standi of the petitioners as persons not being agriculturists, not studying in village, it is seen that the present petition is claimed to be in public interest and violation of statutory provision in making the grant is alleged. Hence, the said allegation in any event requires consideration by this court on merits. The principal ground of attack is that the lands in survey numbers 26 and 27 of so and so there are Goma land, and the grant is contrary to section 71 and 72 of the Karnataka Land Revenue Act. In this regard, the contention that the land in question is reserved for the free pasturage and since the village consists of 1,500 acres of cattle and also sheep and goats, the same is to be retained for such purpose. It is contended that the procedure contemplated to reduce the restricted Goma land has not been followed. Government counsel to the petitioners has said the land is in the first above cases, we should know what the procedure is required to follow for the purpose of diverting Goma land. However, the question in the case on hand is as to whether the land in question can still be considered as Goma land even as on the date of grant merely because it was classified as such on an earlier point. That was the question. Further, in the latter of the cited cases, the conclusion therein was reached in circumstances. The land in question, which was earlier classified Goma land, greenbelt and earmarked residential purpose and comprehensive development land, were subsequently acquired by industrial purpose. But in the instant case, considering the nature of the events put forth, wherein it is contended the land in question had lost its character of Goma land, the matter requires examination in that context. As such, the situation not being analogous to each other, in the case of hand and in the cited petition, the same will not assist the petition. In that manner, it is noticed that even though the petitioners have contended that the land has to be reserved as Goma land, except for the bond assertion, they have not placed any material on record to establish that the surrounding lands have declared the agricultural lands, even as on date of the grant, and that there existed cattle, sheep, and other animals to the extent as stated in the petition. Instead, the very ground number 6 raised in the petition to contend violation of the Karnataka Land Grant 1969 would indicate that it is the admitted case of the petitioners that the land in question is in the vicinity of Bangalore City. This is the property of something engaged. In the present instance, in any event, Rule 10 is not violated. Since the same grant is not subject to such a situation, the position is that the land in question are urban lands cannot be disputed in the petitions. On the other hand, respondents have contended that the lands in question had lost the characteristic of Goma lands, and as such, there was no requirement to either reduce or extinguish the Goma land by following the procedure contemplated under Rule 97 or the Karnataka Land Revenue Rules. No doubt, in the order dated 22/6/2001, wherein the government granted approval for grant in favor of respondent report, it is indicated that approval is accorded for grant after reducing the Goma land. But in the present case, similar amount, even in the grant order, it says we have de-reserved it from Goma land. Similar. Now, kindly see how the division bench approaches the matter. But in the present facts, that in itself does not lead to a conclusion that there has been non-compliance with procedure. Such indication appears to have been made in usual course. We find that to be so, since in the order dated 20th of September 2000 made in third respondent, in respect of another portion of land in the same survey, there is no such observation, even though the order is at their point of time. Further, the report dated 8/5/2000, submitted to the Assistant Commissioner and Special Deputy Commissioner when examining the proposal, refers the location of the land as being within 18 kilometers distance from the Bangalore City Corporation and being situated on the side of the public road leading from Bangalore Sarkar Flower and passing to the new prison in Nagarathpura. It is in that context, respondents number 1 and 2 have referred to that aspect in their objection statement and have stated that it is within the territorial jurisdiction of the BDA. The above contentions related to the nature of the land as on the date of grant has been buttressed by respondents 3 and 4 with reference to documents. Then there are some documents that are referred. Now, your Lordship may kindly go straight away to paragraph 30. all other countries, can you see, Balaji? Having given our consideration to the above facts involved and the contention, we are of the opinion that even though the lands in question were initially classified as Gomar land, at a time when it was in the village, it had thereafter lost its characters of Gomar land due to the growth of diversity and its location being within 18 kilometers. This is evident by the fact that the lands in Kasavanalli came to be included in residential road in the CDP. Such zoning of land use and regulations made for the Bangalore local planning area under the provisions of the Karnataka Town and Country Planning Act would be governed by the provisions of that act, since it will have overriding effect as provided in the Committee. I pause for a moment here to therefore say that whether a particular property is Gomar land or not is not something that is to be inferred only from what is recorded as history. The question, which I would say is relevant, is to find out what is the position of the property as of the date of the grant. Was it Gomar land? That's the question, that you will have to kind of look at. And in the instant case, the assistant commissioner who granted the property, please look at that order. So the order, which has been passed under the provisions of the Inter-Subordination Act. So if you also will kindly look at that order, there is a statement. Now, what was the inquiry that was made prior to that finding? Is a matter which the government has to place records for your lordship's consideration to see what was the inquiry made in order to find out as to whether in fact it was Gomar land or not. Please see that order for a minute, my lord. The order dated 1/2/19. The order dated 28/5/1967, which your lordship will find in annexure R5. But kindly look at our statement of objection. 3937. Page number 39, 37. Page number 59. Statement of objections filed by respondent number 10 to 39. Statement of objection. The date of filing 20th of December 2021.
You have filed statement of objection in WP number 24123. The petition filed by the state.
No, no.
Being respondents, you have filed.
No, I'm talking about the petition filed by King. 3937.
In their petition.
No, in the petition filed by King, you all respondents. You all respondents in that. That is what I am referring to. I'm sure it will point out your lordships again. I am pointing here only with reference to this point that in the order passed, my lord, by the Special Deputy Commissioner under the Inter-Subordination Act, there is a very telling finding that has been recorded. And that is a finding recorded as of 28th of May 1967.
Page number?
My lord, I am page number 59, annexure R5. In the statement of objections filed by respondents number 10 to 39. In the statement of objections filed by R3 to R7 also it has been produced. At page number 11. You can also take that one, that's perfect.
Order of the Assistant Commissioner.
Respect. Order of the Special Deputy Commissioner. Under the Inter-Subordination. This has to be viewed in the context of the law laid down in the division bench submission and making.
Compilation idea.
Order date.
Order dated 20th of May 1967. There is a grant. The inaugural grant. Now the statement of position has been. It is to be convenient.
173. Bookali 173.
Because I have marked everything in that, it will be easier.
Yes, sir.
Mr. Hubli may be directed to give me copies. The learned senior counsel just read. I am not given a copy of it. Tavi Vodadu. Division bench. Division bench. Thank you.
Yes.
Now, Lord, please be kind enough to turn to that order. If I may trouble you not to kindly see internal page number 3 of that order. Exactly the approach as stated my lord by the division bench has been adopted by the learned deputy commissioner in the submission I am making. Since these lands, so now kindly turn to the bottom of the page 2 on bottom of page 2, internal page 2. The inquiry conducted by me goes to show the bottom one.
Yes, yes.
The inquiry conducted by me goes to show that the land claims survey number 66 and 199 are not Karab or Goma lands, and they are under cultivation. And the petition has been in possession and enjoyment ever since he purchased, and the Jodhiyar was cultivating these lands prior to him. Since these lands have lost its character as Goma or Karab, since these lands have been brought under the cultivation prior to the vesting of village in government, the petitioner's Venkataramanappa is registered as a permanent tenant in respect of survey number so and survey number 199 under section 5 of the Mysore Personal Insurance Premium. Premium is levied since the petitioner has himself admitted that the rent paid by him in Florida prior to the vesting is more than that. So Lord, there has been an application made by the Special Deputy Commissioner on whether this particular land has ceased to be a Goma land by character. And the statement will not record is that there is an inquiry conducted. What inquiry has been conducted by him is a matter that doesn't disclose the records. It can't be either by my affidavit or by the affidavit of any party. So therefore, if you want to go into this question as to whether it is a Goma land as understood by the Special Deputy Commissioner and in the light of the law laid down by the division bench of the Sound of Court, then my lord, it would be necessary for the government to produce records before your lord. See, with regard to these proceedings, to find out what inquiry. Maybe my lord, some inquiry was done. We don't know that. So that is my submission, my lord, with respect to this Goma land. Then my lord, there is one other judgment which is relevant for your lord's consideration. Now, my lord, this question as to whether a particular property can be said to be Goma property or not. Is it something that can be gone into in a writ petition? Was a question that arose before a coordinate bench of this court. That's what they did. But that's also a division bench, I'm sorry. Kindly see the memo by the first step. The lodgers will be kind enough to take paragraph number 9 at page 6. It is clear from the objection statement, paragraph number 9 at the bottom of it. It is clear from the objection statement filed by respondents 1 to 4 that the land had lost its characteristic of Goma land due to its topography and location, and the amendments made in the petition also shows that the request made by the villagers for allotment of land comprised in the said survey number 64 for the establishment of schools and other purpose, and also for construction of residential houses, and the same has not been granted to the government. The said question as to whether the land comprised in survey number 64 has lost its characteristic of Goma land is a pure question of fact, which requires detailed investigation by holding an inquiry. It cannot be done in excess of power under Article 220 of the Constitution. Now, that inquiry has been done by the president. Now, the question that I place for your kind consideration is whether that finding of fact can be examined by this court in proceedings under 226 where the law. And if your lordships do think that such an inquiry is permissible to whatever extent, limited extent or detailed extent, whatever extent, then it cannot be based upon the assertion that is made by any of the parties. It is a matter which has to be decided, if at all, on the basis of the records which the Special Deputy Commissioner will have to be produced before the lodges, because he says on inquiry, I am satisfied. And therefore, an independent inquiry by this order on whether the property is Gomar property or is not Gomar property, or whether the property has lost its characteristic as Gomar property, I would expect the subject is beyond the pale of investigation under Article 226, having regard to the law laid down in the division.
That is why the learned additional advocate general also said, please remand the matter back. Let them.
There is nothing for remand. No, remand, I would say, my lord. In fact, I would prefer not having regard to this matter. Your lordship kindly see is an order passed in 1960. My lord, remand. I would respectfully submit, Lord, please adopt the same approach which the courts would normally adopt in civil matters. Remand alone is not to be done simply for the asking, saying some doubt, I will remand it. Is this something that requires a further investigation? If an investigation has already been done, and the records do indicate that the remand that investigation has been done, my lord, then we will not be for demand. Then, my lord, the court will say, well, am I satisfied on the basis of the records that all relevant considerations have been gone into in coming to this conclusion, and inquiry has been duly and properly done. If the inquiry has been properly done, then, my lord, by reference to submission to duly demand. It can't be a second look. And no, my lord, I ask myself, suppose now, the Deputy Commissioner, as he has indicated in his order, now it is there in his order, I am not saying so on my own. The Deputy Commissioner in his order says, I have made an inquiry, I have satisfied that this property has lost its character as Gomar. He cannot check point on the record of the Deputy Commissioner that there has been sufficient inquiry. I ask myself, why should there be remand? Remand is not to be ordered for the asking. Remand, in fact, for not as your lordship are aware, in civil matter, remand is a remedy of last resort. If there is material available, even if the approach of a particular court, whether the original court or the first appellate court is wrong, if the material is available, but the law is that even in the second appeal, the court can use that material to form a conclusion. So I ask myself, why should we remand? Please look at the record and you can make this litigation 1 year and try to see what is happening in the I will make a submission on behalf of the petitioner. But it is said that the Karnataka Another Institute is a government of Karnataka undertaking. They are engaged in some research and for the welfare of so many people and all that. And that they are not now allowed to develop the property because the order, and but I want to point out to the lordship, the order passed by, in the interim order passed in this petition. In fact, that order has not been challenged by them. What is the effect of that order? In the light of all this, I ask myself, is it not illegitimate the petitioner also to put an inquiry to this? And then say, well, either I am right or they are right. It is either their property or it is my property. 1 year after they if you not to the conclusion that this property is the property belonging to us, then the order is they will get an alternative. If the property is theirs, so be it. It's over. What public interest is served by simply delaying this, well, now not remanding to the President of the Commission. He passes some order. Against that order, not appeal to the appellate tribunal and petition to this court. When is it going to end? You have already seen this litigation go on now for how many years now? From 1967. So please keep that in mind, my lord. With this remand submission, I would say, my lord, is legitimacy to the interest of all parties, whether it is a respondent or the petitioner or whoever. If it is actually Gomar property, and we cannot have come to the conclusion that on the basis of the record that you are not in my humble submission to call for, and come to conclusion, no, there is abundant material to show that this is Gomar property. No, no, it's again in public interest to put a white stress. Neither the letter institute will get it, not the respondent will get it, nobody will get it, it remains as home property for the benefit of the actual village. So optimal. Within a particular time frame, please ask the government to produce the records before you are not checked. It can be done, your choice, the time. Order not passed by the Special Deputy Commissioner. Time can be called, you will not check 2 days time. Let the records come, your lordship will see it and then make up your lordship's mind. Not on the basis of convictions that are made across the bar, saying please call for it. That's my submission. Now I want to point out to your lordship, one interim order has been filed, and this is in support of my submission. Please call for the records. Kindly see the interim order that has been filed. It's a very damaging order so far as the petitioner is concerned, namely the Karnataka Leather Institute. Please be kind enough. No, it is interim order dated 28/11/2014. It is produced, my lord.
Original records ಇದೆಯಾ? Original records ಇದೆಯಾ?
Statutory proceedings, so lordship can look at it.
Original records from where? Huh?
ಭದ್ರವಾಗಿ ಚಿನ್ನ ಬೆಲೆ
Those papers would be so fragile.
I know.
Even if you touch them, I think probably.
So there are no black money to input that.
What if? Please give it. Like the records of the tribunal. You are furnishing records of the revenue department. The special deputy commissioner. No, probably it was not summoned. Probably it was not summoned. I will summon it. Yes. Yes.
Well, because he says so, Lord. He says inquiry conducted by me.
But the problem is, at the first instance, in the year 1962, there is a 62 at the first instance. In the year 1962, when the special deputy commissioner passed the order, our point out madadalla nama Ravi Shankar avaru. There are about 8 to 10 orders where they have clearly stated that it is a gomal, it cannot be granted. Therefore, if in the subsequent proceedings, if the special deputy commissioner were to hold that I have conducted an inquiry, and for these reasons, I find that these were not gomal lands. As on that day, not on the day when he is looking into the records, because the provision says, section 10 says, Gomal cannot be, occupancy rights in respect of Gomal cannot be granted. So,
It should be as of 1959.
the judgments that you have cited is in a totally different context under the provisions of the Land Revenue Act. So to that extent, they may not be of great help to you, because section 10 says very clearly, when considering an application under section 5 or section 9 for that matter, the lands that are earmarked as Gomal and other, there are so many other things which are precluded from being granted.
Possible that has to be written as of 1959. Yes, sir.
As on the date, as on the appointed date. Appointed date, yes. So therefore, I had requested, I have called upon all the learned councils, in fact, even the learned AAG for that matter. What is that inquiry that was conducted?
We know that is records was indicated.
That's what.
Records was indicated. As I mentioned just a while ago, whatever may be said with the parties. This is such a proceeding.
Correct. So that is
Whatever
why
we may say, whatever material we may produce, my runner may produce material stored with Goma and I may produce material stored is not. The question is, what is the inquiry that was conducted as referred to in the order? Because as lordships are well aware, an order has to stand on the basis of what is stated there. You cannot improve the order by any reason. Therefore, all that I'm saying is, please look at the inquiry that has been conducted. I don't know what inquiry has been conducted. I don't know. But you can. So please ask them to produce the records of the special deputy commissioner. Maybe that has some material. If it is no material, then I agree that this finding recorded by him is completely incorrect. But I would not think that in an order which has been passed on 25/5/1967, and even though there were proceedings arising out of the order on several occasions, but this contention that this is not Gomal land and this finding is not.
that was the contention.
No.
That is why it was remanded, in fact.
No, it was not remanded for that reason.
There was an objection raised at the hands of the government that
No, I'm not talking of the challenge to this order. Okay, the order passed. Now can you see the reason why it was remanded? Please look at the order passed by the. But before that, can I point out the interim order has been passed? That's a very important order. And I would think on the basis of this order which has become final. In fact, I would not call this an interim order in the traditional sense. But as your lordships are aware, just because an order is passed during the pendency of a proceeding, it does not necessarily mean it becomes an interim order in the sense as merging with the final order. Please look at the order that has been passed by this honorable court on 28/11/2014. It has become final.
Yeah.
Here is WB number 3937 of 2010.
That is done separately, is it?
Yes, it is a separate order. I think it's not in the order sheet. It is separate. 28/11/2014.
In WP number?
3937, the one that I'm now making.
Collected 10,017 to 21. Both were collected and interim order came to pass.
What is that order dated?
28/11. I think it must be a separate order, not maybe it will not be the order sheet because it's a long order. It's a long order. 28/11. Order sheet is the long order, therefore it may not have been typed in. From what I can see, it seems to be a separate type. Separate type. I'm not sure whether this was brought to your lordship's notice. We may read this order in a short order. The facts in these petitions are the survey number 199 of Ullal village, Yeshwanthpur Hobli, Bangalore, North Taluk, comprises of vast extent of land. According to the contentions, the petitions in WP number so and so and so. The above land was Inam land and they have purchased the same from its original tenant Venkatramanappa. Alias Dottanna, Venkatramanappa so and so had filed an application for regrant of the land to the Special Deputy Commissioner. The land in the said survey number and adjoining survey numbers were regranted in favor of Venkatramanappa. However, the claim in respect to certain extent of land has been rejected to the Special Deputy Commissioner on the ground that he has sold the property in favor of these petitions. Agreed with the rejection of his application, the vendor of the petitioners herein has filed an appeal before the Karnataka Appellate Tribunal, Bangalore, in appeal number 121 of 1978. In the meanwhile, the state of Karnataka, considering that the said extent is a Gomal land, granted 100 acres in favor of the petitioner in WP number 3937 of 2010. That is what is Karnataka, the Institute of Leather Technology. 10 acres in favor of the petitioner in WP number 3937 of 2010. Another 10 acres in favor of police department. The dispute arose in regard to change of mutation. Therefore, the present petitions are filed. After hearing learned counsel for other parties, this court has noticed that if ultimately the appeal filed by Venkatramanappa before the tribunal is rejected on the ground that he had no saleable interest, the purchaser of the said land or petitioners in WP number so and so have not acquired any title, even though the land in question is Inam land, since it vests with the government, and the government has every right to grant land even if it is not a Goma land. If ultimately the appeal is allowed and the order of regrant would endure to the benefit of the purchaser of the land, then the grant made by the government in favor of petitioner in WP number 3937 of 2010 and the police department would deem to be cancelled, since the government has no power to grant an Inam land, which is a subject matter of regrant. Now, my lord, we are in that situation today. Now, this order, my lord, which says that they have accepted it. They have accepted it, saying yes, if the tribunal, the appellate tribunal allows the appeal, then my petition can go. I asked myself whether the appeal is allowed. I asked whether they have accepted this order. How can they now stand up and tell your lordships, no, I am not bound by this order. But I am quite conscious, Lord, that the order is under challenge. The grant order is under challenge. But so far as guilt is concerned, they are not challenging the grant order. They want to challenge.
They cannot challenge it also.
No, therefore not.
Therefore, when the government has challenged that, they are.
Yes. Separate. Yes. So far as Karnataka Industries, the Institute of Leather Technologies, their petition must be discussed on the finding recorded by this honorable court on 2011-2014. Therefore, to that extent, the controversy should be set at rest. Now, if this is the position so far as they are concerned. Now, let us come to the government standards. My first objection to the government's writ petition, my lord, is that this has been filed after a delay of 5 years and 2 months. Now, that itself is the ground, and in the writ petition, my lord, what is the reason for delay? Please look at the reason, my lord, is 10,174. Please get the government's right. If the private petitioner was before your lordship, after this delay of 5 years and 2 months, because your lordship is trying to see the petition filed not in 2021. The order is dated 2015. Kindly see the petition. The order passed by the appellate tribunal is dated, my lord, 30th of June 2015. And the repetition.
What is this writ petition? number 24123 of 2012 filed by the state government.
The order. Today, my lord, what is of importance for your lordship's kind consideration is the order passed by the appellate tribunal, where my appeal has been allowed. And the order passed by the special deputy committee announced about it has been confirmed. Now that order which is subject matter kindly see the repetition is 10,174. And let us see if there is any satisfactory explanation given for these 5 years and 2 months of delay. And my lord, I don't have to cite authorities for your lordship's consideration, but the well-established proposition that delay and latches is better to a repetition, whether it is for a private party or for the government makes no difference. There are no two different yardsticks. Please look at the repetition. Fine.
$1,174.
But let me see para 29 if the explanation is satisfactory. This is, before I read it, my lord, I would like to make a submission in preface. This is simply words without any substance. This can be written by anybody. I mean, after all, what's the difficulty of using these words, bona fide, confession materiality, public interest? What were you doing from 30th of June 2015 to 23rd of July 2020 when the writ petition was filed? Very interesting, madam. Paragraph 9.
Yes.
The petitioner only submits that it is a government body. The officers concerned as well as legal officers keep on changing. Even the CAR Bangalore also a busy body, always busy with regard to elections, riots, violences, strikes in city of Bangalore, security arrangements, etc. Besides that, the advocates who were looking after the petition and the petition were also changed periodically. Therefore, they were not aware of the facts set out above. There was also difficulty in securing the opposite information, informing the council about the setbacks. In fact, under those circumstances, writ petition also could not be filed immediately. The delay, if any, in preparing the writ petition and also pleading the opposite facts is bona fide and out of inadvertence. As subject matter writ petition belongs to the public interest. Public interest is involved and an institution is now being set up which is catering to the needs of public safety and security, and thus it is necessary that the delay, if any, in preparing the writ petition should be used liberally, and the delay should not come in the way of doing complete justice. Well, I pause for a moment here. I ask myself, am I not justified in saying that these are mere words? But if this explanation is good enough, I think why 5 years? Any amount of discussion will be good enough. And that government is not bound by the principle of delay and latches so far as filing a writ is concerned. If this is the law in writ petition, I ask myself, why is it not the law even in other proceedings where limitation period is prescribed? This is good enough reason. Government can always tell an appellate court, now busy agitli, nam bala kelsa ide, nam bari ide kelsa alla. Of course, Lord, cabinet comes, cabinet goes, officers come, officers go, legal officers come, legal officers go. These are all matters of administration, but administration does not go. But that is a very interesting explanation at all. It is very dangerous to accept an explanation.
I will consider that.
Yes. Then, my lord, the other point that I want to point out to your lordship is this. Now, your lordship asked me on the locus. Now, who is the person who made that? The application was made, my lord, by Venkatramana. On the basis of which this order has been passed. Venkatramana purchased the property from one Nagaratama. But the purchase was in the year 1957. On the date of purchase in 1957, in abolition, it was not.
Then, my lord, he purchased the property in 1957. It was purchased. Inam's operation Act came into force in 1959. Now, my lord, Venkataramanappa sold this property under various stages from 1959 to 1968. And thereafter, my lord, the application was filed around. My lord, Special Deputy Commissioner Venkataramanappa filed an application in the year 1959. After the land vested in government. Now, my lord, as on the date of the order, Venkataramanappa, my lord, was not the owner of the entire property because he had executed sale deed in favor of so many people. And in fact, even after the land had vested in the government in 1959, Venkataramanappa has executed sale deeds. For example, my lord, he has executed sale deeds in 1960. And on 1/2/1959 is the date of vesting. And Venkataramanappa, my lord, after the property had vested in the government, has sold the property.
Question is, could he sell the property? Do they derive any title?
No question. He, as on the date on which he sold the property. As on the date on which he sold the property, Venkataramanappa had no right because the property is vested in the government by virtue of the Inam Savali. Now, my lord, two questions for your lordship's consideration. One is, could Venkataramanappa have at all filed an application for grant? Secondly, assuming that his application was in order, since as on the date on which the property was sold to these various persons under these various sale deeds, Venkataramanappa had no title. What is the title that these purchasers can get? Is the question. Not I go down. No, not I have two answers. Please look at the provision of the answer. Now, what is it? I will endeavor to satisfy your lordship in law that on both counts, these respondents are entitled to leave title. Please be kind enough to section 5. Subject to the provisions of subsection 2, every permanent tenant of Inamdar shall, with effect on and from the date of vesting, be entitled to be registered as an occupant in respect of all land of which he was a permanent tenant immediately before the date of vesting. Therefore, my lord, the date to be reckoned for the purpose of section 5 is the date of vesting. Ask the question in my humble submission to you. As on 1/2/1959, who was the tenant? Whether Venkataramanappa was tenant, we complete the next question. I will answer that also. But to find out the locus of Venkataramanappa to make an application when he has lost title and he has in fact sold away the property to somebody else without any title, what is his locus to make an application? But my respective submission is the question must be asked with reference to 1/2/1959. As on 1/2/1959, the date of vesting, who was the permanent tenant on that day? So if the claim is that Venkataramanappa was the permanent tenant as on 1/2/1959, then he is entitled. That is why Lord Section 5 uses these words twice. I'll just point that out and leave it at that. Every permanent tenant of the Inamdar shall, with effect on and from the date of vesting. It is on, not only from the date of vesting. On the date of vesting. Are you a permanent? Then we are not having said that. It goes further to say, be entitled to be registered as an occupant in respect of all lands of which you are permanent immediately before the date of vesting. Therefore, this date of vesting, my lord, is used twice. Every inquiry, therefore, has to be with reference to that date, namely 1/2/1959. Therefore, the question which I would respectfully request your lordship to answer is, as on 1/2/1959, who was a tenant? Who made the claim? Whether he is a tenant or not, the tribunal has to decide. That's a different matter. I am on the question of locus.
Yes.
Therefore, the determination of the question of locus must be with reference to 1 to 99 and answers. That is my answer to your lordship's question. Could Venkataramanappa have filed this application at all? Now, if we cross that threshold, that yes, Venkataramanappa could have filed an application as of 1 to 1999 because as of 1 to 1999, Venkataramanappa claimed to be a permanent candidate. From then the question would be, is he entitled to be registered? Finding, which your lordship will examine, is that entitled to register. Now, Lord, in the meantime, after the date of receipt, properties have been sold. Admittedly, that I'm not disputing. I can't dispute. I can't. You cannot. It will be completely against the law if I say that. Yes. That as on the date of the various sentence, namely between 20th of July 1959 and 15th of February 1968, these I think the 10 sentence, Venkataramanappa was not one. What is the effect in law of a person who has no title to the property selling the property if he acquires title after the sale? But the law is quite clear. Please be kind enough to turn to section 43 of the Transfer of Property Act. It is a relevant principle. Let's forget the factual background. Let us take a situation where a person who has no title to the property today sells the property, and 5 years later he acquires title. True, as of the date of sale, no title, the purchaser got 0. But if 5 years later, my vendor got title to the property, am I left in the lurch? The law says no, you are not left in the lurch. Please be kind enough to consider section 40.
Yes.
Where a person fraudulently or erroneously represents that he is authorized to transfer such an immovable property and professions to transfer such property for consideration. Such transfer shall, at the option of the transferee, operate on any interest that the transferor may acquire in such property at any time during which the contract of transfer subsists. Therefore, my lord, if the order that is passed by the Special Deputy Commissioner of Finance Abolition ensures the benefit of my vendor, even though as on the date of sale in my favor, my vendor does not have title, that acquisition of title by my vendor at a subsequent date will end to my. That is what is called, my lord, in law as reading the grant rates. Yes. This is how I would say, even though I cannot acquire title as on the date of my sale date. But if this order is right, that of course, not that I am not going to repeat the submissions on the correctness of the order, and according to me, the only ground is Goma land which I want to make my submissions on. And I don't think this order otherwise requires that the instance of the government who has come after 5 years. So therefore, to say who are you? You are no right. He is not a sufficient. I would respect this subject. He ignores the mandate of section 43 of the Transfer. This is my respectful submission, my lord, on these two aspects that you are asking. And just one last submission, my lord, in this in the repetition that has been filed by the skill. Please get what is question. Kindly turn to page 59 of the repetition. This is a communication dated 28/1/2010. That is all that happened. I'll read that for your lordship's consideration, Lord, and kindly see. By this order, this communication seems to be correct according to me, and therefore given on minutes, his repetition was used. Government repetition, I have already made my submission. On Goma line, my lord, they have to produce records. Without records, it cannot be decided. And my lord, please consider the question. This is my submission on the government repetition. On Kid's repetition, please see what is challenged. The only question they are asking for is in respect of Annexure W, dated 28/1/2010. Can you see what is?
Due respects, I've already made a submission that may not survive in view of the subsequent. Helbody. Helbody.
Since the 38 has been withdrawn, I'm not.
Yes. Yes, Mr. Bhatt. Taನೆ? No. It's all right.
Which we have. This is not pertaining to lot. Let me have that. 36 acres. 1964 order that all orders are in favor of Venkatramana from the beginning 1967 and we are technical and we are discountable report that given by so far as we are regarding Gomala and government has got the that request is there. Therefore, ABC in order pass that is not my control. That is not the non-receivable. Lecture R page number 160. Let's get clear right here. Insofar Gomala is concerned, the government has reminded that the deputy commissioner has notified them. Therefore, insofar these questions is concerned, they have submitted that there is no creative government satisfaction. That has to be confirmed with this. Therefore, respect of not all values and not this one would consider twice. In the Lord, there are two petitions and interview has to be done and demanded. And thereafter, obligated that is also the those that comes to insofar as 24 122 of 2012 filed by the government as against who has purchased from Nagaland in respect of available 40 acres, they have done. This 24 122 our grant are not subsequent or participant and start being carried 24 122. Insofar as it is concerned, government retribution as against the therefore, my
yes. But in this case, I am appearing for some of the respondents. My application for impleading allowed. In that application, I have produced. Petitioner said that they have purchased in the year 1950.
Who are the?
We have been granted some sites, my lord. We have constructed the house and we are residing. Granted by the government. And we are there, my lord, and our application for impleading allowed. In that application, my lord, annexure R1, Nagaratnama purchased the property by virtue of sale date dated 10/11/1947. Earliest sale date. In that sale date, there is a recital that Nagaratnama has not acquired any property in respect of government Gomala land or Sarkari land, which have been specifically excluded in that sale date. And what was excluded in favor of Nagaratnama, she cannot sell it to Venkatramana. And then, my lord, annexure R.
Is there a copy of that?
That is annexure R1 produced along with the impleading application.
Impleading application.
52118 of 2017. And then, my lord,
In annexure R6, the purchaser from Venkataramanappa made an application before the DC. That those applications have been rejected by that entry is made in the part number 8. That is annexure R6. When the purchaser have lost it, they have not preferred any appeal. Venkataramanappa subsequently could not have filed it. And one submission made by the petitioner.
Did Venkataramanappa file 2 applications?
Afterwards, when the purchaser failed, it appears that he made one more application.
So initially he had made an application.
Initially, he had not made an application. He sold, kept quiet.
Who were the parties who made the first application?
Purchaser.
Purchasers.
Purchaser.
And their applications were rejected.
Rejected. Thereafter,
they did not challenge those orders.
Not challenge.
Those have attained finality.
Yes.
Thereafter, Venkataramanappa filed.
Started. This is one aspect. Yes. Another one, my lord, my friend said that 5 years delay in government filing the requisition. When they,
you please, no. You confine yourself.
Their delay 21 years.
It's all right, sir. Yes.
Annexure R1 is the copy of the sale date dated 10/11/1947.
R1. Page number?
Page number 19. In the IFR implementing. Nagatama purchased this property from one Narayan Rao Mane.
Page number 19. Yes.
Sale deed dated 10/11/1947.
Yes.
In that, my lord, the area which has Gomala all have been excluded specifically.
Yes, please read the.
That is, sorry, my lord, what happened? I furnished a copy to the government. I could not. Correct.
I have got that. Whatever he is pointing out, I have got that. Let him read it. Let him read the relevant portion.
1947. My lord, it's a typed copy is available.
ಇಲ್ಲ ಇದೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕಾಣಿಸುತ್ತೆ. there is no difficulty.
Sale it executed on 10th day of November 1947.
Page number 11 is the schedule.
Correct.
ಓದಿ.
Uladu and its Dakla village, Basti and Lukipalda situated in Yeshwantpura Hobli, Bangalore, North Taluk, bounded on the east by Gidada Konana Gadi, Mallathanahalde Gadi, and Nagadevana Gadi, west by Mangamanahalde and Poda Gadi, north by Harahalde Gadi, south by Ramasandra and Sannehalde Gadi. The land situated within these boundaries, measures 908 acres, Muntas, out of which 285 acres of Kharab land of the remaining extent of 400 acres of dry land are in the possession of Kadim tenants. 6 acres of wetlands are in the possession of Kadim tenants. Out of the remaining extent of 74 acre is the extent of wet and garden land in which no person has got any right, and the same is in the actual possession and sole enjoyment of the first vendor. The remaining extent of land is dry land and is in the actual enjoyment of the first vendor, and measures about 140 acres. In this land, there are 3 so and so and so, one other spare for one so and so, a bungalow measuring about 100 by 90 feet with a well and hand pipes, an RCC roofing office room. There is also one other factory house measuring so and so, Chinmaya 12 Paprika and 4 Ashina Mesa, together with 15 HP motor, sugar cane crusher and 2 centrifugal machine with its ball bearings, mine shifting complete. There is also 200 feet pipe, so and so. There are also 2 galvanized tubs on either pump with the board set, etc. There is also 4 bullock cars, so and so. There are 2 tanks. This next bit belonging to the first vendor, Amrin. All the mobiles and livestock.
Now, what was sold by Nagarathamma?
That is a 1957 sale date. They claim.
Where is that?
That is they have 1957.
In favor of
Venkatraman.
that you want to see. That's a Nagarathamma.
Dated 12th of September 1958.
13-12-57.
In favor of
R2 ಅಲ್ವಾ?
ನನ್ನ
ಇವರದಲ್ಲಿ ಟೈಪ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಅದೇ ಕಾಪಿ.
ಅಲ್ಲ, ನಾವು ನೋಡ್ತಾ ಇರೋದು ವೆಂಕಟರಮಣಪ್ಪ ಅವರ ಹೆಸರಿಗೆ ಬಂದಿರೋದು.
ಹೌದು. 13-12-57.
Page 67 in my book. Compared
ಈ ಬುಕ್ ನಲ್ಲಿ ನೋಡ್ಬೋದು. ಅದು ಟೈಪ್
67.
ಇದರದ್ದು ಟೈಪ್ ಕಾಪಿ ಸ್ಟಾರ್ಟ್ಸ್ ಫ್ರಮ್
71.
Yes.
ವೆಂಕಟರಮಣಪ್ಪನವರಿಗೆ ನಾಗರತ್ನಮ್ಮ ಎಂಬರು ಬರೆದುಕೊಟ್ಟ 41 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ರಾಜಕುಮಾರಿ ಗುಪ್ತಾ ಇವರು ಶ್ರೀ ರಾಧಾ ವೆಂಕಟೇಶ್ವರ ಇವರು ಬರೆಸಿಕೊಟ್ಟ ಶಿರಸ್ವತಿನ ಖರೀದಿ ಪತ್ರ. ಅದಾಗಿ ಬೆಂಗಳೂರು ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಸೇರಿದ ಉಲ್ಲಾಳ ಮತ್ತು ದಾಖಲೆ ಗ್ರಾಮಗಳು ನುಗ್ಗಿಪಾಳ ಗ್ರಾಮಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ 10-11-47 ತಾರೀಕಿನಲ್ಲಿ ಮೇಲ್ಕಂಡ ನಾಗರತ್ನಮ್ಮ ಮತ್ತು ಶ್ರೀಮತಿ ರಾಜಕುಮಾರಿ ಗುಪ್ತಾ ಇವರುಗಳ ಹೆಸರಿಗೆ ಹುಟ್ಟಿರುವ ರಿಜಿಸ್ಟರ್ ಕ್ರಯಪತ್ರದ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ವಿವರಿಸಿದ ಸಮಸ್ಯೆ ವಸ್ತುಗಳನ್ನು ಮೇಲ್ಕಂಡ ಶ್ರೀಮತಿ ನಾಗರತ್ನಮ್ಮ ಮತ್ತು ಶ್ರೀಮತಿ ರಾಜಕುಮಾರಿ ಗುಪ್ತಾ ಅವರು 10-11-47 ಮಾರ್ಕ್ ಲಿಸ್ಟ್ ಕ್ರಯಪತ್ರ ಪ್ರಕಾರ ಸದರಿ ಸ್ವತ್ತುಗಳ ಸಂಪೂರ್ಣ ಮಾಲೀಕತೆಯನ್ನು ಪಡೆದು ಅನುಭವಿಸುತ್ತಾರೆ. ಈ ಸ್ವತ್ತುಗಳ ಪೈಕಿ ಈ ಕೆಳಗೆ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ವಿವರಿಸಿರುವ ಮತ್ತು ನಮ್ಮ ಖುದ್ದು ಸ್ವಾಧೀನ ಜಮೀನುಗಳನ್ನು ಈ ದಿವಸ 3,000 ರೂಪಾಯಿಗಳಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟು ನಮ್ಮ ಸ್ವಂತ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಶೆಡ್ಯೂಲ್ ಜಮೀನನ್ನು ಈ ದಿವಸವೇ ನಿಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ ಕೊಟ್ಟು ನಿಮ್ಮಿಂದ ಖರೀದಿ ಮಾಡುವ 3,000 ರೂಪಾಯಿಗಳನ್ನು ಬೇಬಾಗಿ ಕೆಳಕಂಡ ಸಾಕ್ಷಿ ಮುಕ್ತ ನಿಮ್ಮಿಂದ ತೆಗೆದುಕೊಂಡಿರುತ್ತೇವೆ. ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ನಮ್ಮನ್ನು ಹೊರತು ಬೇರೆಯವರಿಗೆ ಯಾವ ವಿವಾದ ಹಕ್ಕು ಅಧಿಕಾರವಿರುವುದಿಲ್ಲ. ಶೆಡ್ಯೂಲ್ ಜಮೀನು ಯಾರಿಗೂ ಯಾವುದು ಸ್ವಂತ ಕೀಲಾಗಾಯ್ತು. ಈ ಶೆಡ್ಯೂಲ್ ಜಮೀನಿಗೆ ಸಾಲಿನ ಎಕರೆ ಒಂದಕ್ಕೆ 100 ರೂಪಾಯಿ ಪ್ರಕಾರ ಹಾಗೂ 54 ರೂಪಾಯಿಗೆ ಮತ್ತು ಸೆಸ್ ವಗೇರೆ ನೀವು ಕೊಡಬೇಕು ಬರ್ತಕ್ಕದ್ದು. ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು ನಿಮ್ಮ ಇಷ್ಟ ಪ್ರಕಾರ ನೀವು ಅನುಭವಿಸಿಕೊಂಡು ಬರ್ತಕ್ಕದ್ದು. ಒಟ್ಟು ಸ್ವತ್ತಿನಲ್ಲಿ ನಿಮ್ಗೆ ಒಂದು ಭಾಗವನ್ನು ಮಾತ್ರ ವಿಕ್ರಯಿಸಿದ ಈ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಯಾವುದೇ ಕಾಗದವನ್ನು ನಿಮಗೆ ಕೊಡಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಈಗಲಾಗಿ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ 54 ರೂಪಾಯಿ ಗವರ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಪ್ರಕಾರ ಸಲ್ಲಬೇಕಾದ ಸೆಸ್ಸುಗಳ ಪಡೆದು ಹೊರತು ನಮ್ಮ ಗಳಿಕೆ ಮತ್ತು ನಮ್ಮ ಹೊರತಾರು ಯಾರಿಗೂ ಆಗ್ಲಿ ಬೇರೆ ಯಾವ ಹಕ್ಕು ಇರುವುದಿಲ್ಲ ಹೇಳಿ ಬರೆಸಿಕೊಟ್ಟ ಸ್ಥಿರ ಸುತ್ತಿನ ಪತ್ರ. ಅದಾಗಿ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿಗೆ ಸೇರಿದ ಉಲ್ಲಾಳ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 3 ಪೈಕಿ ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟಿರುವ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದು ಪೂರ್ವಕ್ಕೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ರೋಡ್ ಮತ್ತು ಅಕ್ಕಯ್ಯಮ್ಮನ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ನಮ್ಮ ಬಾಬ್ದು ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ನಮ್ಮ ಬಾಬ್ದು ಜಮೀನು ಮತ್ತು ಅಕ್ಕಯ್ಯಮ್ಮನ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಹೊಸದಾಗಿ ನಮ್ಮ ಜಮೀನಲ್ಲಿ ಮಾಡಿರುವ ಹೊಸ ರೋಡು, ಈ ಮಧ್ಯೆ ಇರುವ 36 ಎಕರೆ ಕೃಷಿ ಜಮೀನು. ಈ ದಿವಸದಲ್ಲಿ ಸರ್ವೇಯರಿಂದ ಅಳತೆ ಮಾಡಿಸಿ ಅಚ್ಚುಕಲ್ಲು ಹಾಕಿಕೊಟ್ಟರು ಎಕರೆ ಕೃಷಿ ಜಮೀನು ಕ್ರಯಪತ್ರ ಸೇರ್ತದೆ. Then my lord, if you look into the area which has been granted to Venkatramanappa in the year 1964, 64 is granted. In the year 1964, land has been granted to Venkatramanappa. If you count that area, my lord, it comes to 36 acres, not in survey number 199. Its fight for 199 started afresh. Other survey number has been granted to him, new numbers, in the 1964 order. That 64 order is also produced. 1964. Once page number 161, my lord. Under section 10 of Inam Abolition Act. ಸರ್ವೆ ನಂಬರ್ 56, 67, 63, 64, 105, 106, 115, 131, 132, 133, 134, 137, 208. ಇಷ್ಟು ಜಮೀನನ್ನು ನಾವು ಕೌಂಟ್ ಮಾಡಿದ್ರೆ ಅದು what he has purchased is equal. In the next page, 162, claim. Page number 162, second para. Claim for survey number 199. Survey number 199 is classified as Gomala, having an extent of 84 acres, 3 guntas. The petitioner had claimed 36 guntas out of survey number 199. He has not stated how he got this land and since how long he is in possession. The villagers have petitioned both to the special deputy commissioner for Inam abolition and to government to reserve the Gomala land. It is also alleged that Jodidara had sold this Gomala and without permission of the deputy commissioner as per rules. The Jodidara has not obtained permission of the deputy commissioner of the district to sell to these Gomala lands, and the petitioner has not proved his long possession. His claim for the above land is vague. The revenue authorities have reported that there are 756 big and fine and small heads of cattle in the village, and the Gomala is grossly inadequate. Hence, the claim of the petitioner is rejected. This rejection by the deputy commissioner, ultimately after remand also, rejected by order dated 17/178. That order was challenged after lapse of 21 years, both by Venkataramanappa and when this finding is clearly given, deputy commissioner at that time, it is classified as Gomala. The finding of 1964, undisputed point. Therefore, they are not entitled to claim this land.
Yes.
If I have filed detailed application, in that I also filed the advice by this division, where the claim of so-called authorities have been dismissed already. These authorities, so-called authorities, are either successor of those authorities, whose claim has been already rejected. So last week I indicated my objection, where I have filed a copy of the order.
We are not concerned with their right to remain over the land. We are only concerned with the orders passed by the land tribunal and the grants made by the government in favor of these two entities. We are not concerned with the rest of them. Yes. No, we are not going into that question at all. Yes.
And one more petition is there, last one, 5-2, 118 of 17 minor. That is that on different law of action, now the back shots in here, in that also pertains to the grant made in respect of to the police department. Their grant has also grants also as per the order of the Manjuna, which has been not challenged by the police department. Even though there is an order, because they are interfering with the land, the violation of the Indian order. So that order, final order is passed by the government, the violation of the earlier agreement. That matter has to be heard. The subject matter is the same. All of action is different. Order challenging or different.
No, ultimately, if the government succeeds, they will succeed. If the government fails, you will get back your property. So it doesn't make any difference. Yes, yes. Yes.
I would go along with the argument of the bound by the
yes.
Whatever the argument is for that, I don't think I can go beyond that.
Yes. Regarding the, I may be permitted with 5 minutes. Regarding the question of feeding the Grand Episcopal, the background facts are that 1957 he purchases the property. Thereafter, he sells all the 36 acres to different individuals comprising about 10 people. Then they make an application, they suffer an order, which reaches finality. Thereafter, whether there was any right for Venkataramanappa to make an application is the first point. So, and these people are now the purchasers, thereafter having suffered the order, have come on record before the KAT Therefore, it is the argument that I advanced in an earlier point in time is Venkataramanappa himself did not have the right to make an application. Till today, nobody has either the LRs or the purchasers from Venkataramanappa have not produced the document saying that this is the date that he made an application that is prior to the sale of the property. Number one. Number two, so far as the claims of Mr. Hubli is concerned, there is already an order passed by this honorable court saying that the land granted to Kilt is totally different from the land that is, if at all, that he has purchased. There is a clear finding which this order of this honorable court has also reached finality.
So that is why he was only pointing out to the land granted to the police department.
Senior counsel also argued regarding he is representing Mr. on behalf of Hubli.
Yes.
So, my lord, the question of feeding the grant of estoppel also came up before the Honorable Supreme Court, where, may I just point? The para 6 and 7, I may be permitted to read. 1994 4 SCC 730. Transfer on fraudulent or erroneous representation, conditions for applicability. By virtue of the representation made by the transferor, the transferee must be misled about the transferor's authority to transfer, despite inquiry as a reasonable and a prudent man is expected to make. Further, contract of transfer must subsist when claim made by the transferee pursuant to the subsequent acquisition of interest in the property by the transferor. Respondent mother executing sale deed in favor of the appellant held headlines on facts. Section 43 not retracted. Appellant having failed to inquire about the respondent's competence to alienate the land as guardian of the minor without any permission, and in the absence of such permission of sales, minors having become void at the time of the appellant's claim, both the conditions of section 43 not fulfilled. The conditions are mentioned in para 6 and 7. Condition number 1 is, by virtue of the transferor's representation, transferee must have misled. So here that is not there. They consciously have purchased the property. Number 1. Number 2, the second condition. Contract of transfer, it should subsist when the claim made by the transferee subsequent to acquisition of interest in the property.
Where are you reading?
These are the 2 points that are extracted while reading para 6 and 7. I may be permitted. Next page. These are the 2 highlights of section 43. The feeding the grant of estoppel. 6. It is settled law. Next page. That transferee must make all reasonable and diligent inquiries regarding the capacity of the transferor and the necessity to alienate the estate of the minor. On satisfying those requirements, he is to enter into and have the sale deed from the guardian of manager of the estate of the minor. Under the Guardian Wards Act, estate of the minor cannot be alienated. Admittedly, no such permission is obtained. Next, section 43 feeds its estoppel. The rule of estoppel by deed by the transferor would apply only when the transferee has been misled. The transferee must know or put on notice that the transferor does not possess the title which he represents that he has. When note in the sale deed had put the appellant on notice of limited right of the mother's guardian, as a reasonable, prudent man, the appellant is expected to inquire whether on her own the mother as guardian of the minor's son is competent to alienate the estate of the minor. When such acts were not done in the first limb of section 43 is not satisfied, it is obvious that it may be an erroneous representation and may not be fraudulent one made by the mother that she is entitled to alienate the estate of the minor. For the purpose of section 43, it is not strong material for consideration, but on declaration that the sale is void, in the eye of law, the contract is non-est to the extent of the share of the minor from its inception. The second limb of section 43 is that the contract must be a subsisting one at the time of the claim. A void contract is no contract in the eye of law and never in existence. So the second limb of 43 is not satisfied. The ratio of this court in Jumna Masjid case and all, section 43. So what I'm trying to bring home point now before my lord says that Venkataramanappa did not have the right, as on the day when he made the claim, for these people to say that section 43 is applicable. It feeds the estoppel. It feeds the estoppel that it is not there because he had already lost his right by selling the property. They in turn made an application. They also lost.
Their claim arises only under that sale deed.
Sale deed.
As on the date of sale deed, there was no such difficulty. But if he has sold the property after the appointed day,
Vesting 1 to 59.
after the vesting of the day, they cannot say that though he had no right, we have purchased the property, and thereafter, after he makes an application and he gets a order of occupancy rights.
We step into the shoe. That is not permissible. Because as on 1 to 59, the land got vested. He sells it for 10 people. They make an application. They lose the right. Where is the right for Venkatramana to make it clear?
So these two
Clear.
Yes. All right.
Okay. Lord, there's a fine distinction. Now, in this case, in Karta Singh's case, what happened, Lord, was the mother said, I am selling the property of the minor. Mother did not say it is my property. Therefore, it is not a case coming under 43 because there was no fraudulent statement at all or erroneous statement. Mother did not say this is my property, I am selling it. Mother said, this is my minor size property which I am selling. And permission under law had not been obtained. Therefore, not clearly 43 does not apply. Please see the paragraph. It's very, very clear for us. Ultimately, how your lordships decide on this issue is different. But let us understand Kartar Singh correctly. Now, please be kind enough to turn to paragraph number 6. It is settled law. It is settled law that the transferee must make all reasonable and diligent inquiries regarding the capacity of the transferor and the necessity to alienate the estate of the minor. One satisfied though that the property belongs to the minor, no doubt. Mother is selling the property on behalf of the minor, no doubt. Mother never claimed the property to be hers. So therefore, it is not a case where the transferor is selling a property of which she is not the owner. That is not the situation. Like here, then what can you see? On satisfying those requirements, he is to enter into and have a sale deed from the guardian or manager of the estate of the minor. Under the guardian wants that estate of the minor cannot be alienated unless a specific permission in their behalf is obtained from district court. Admittedly, no such permission is obtained. Therefore, the distinction here is in such a situation where the transferor does not say it is my property. But yes, I am alienating the property belongs to my minor child.
Therefore, let us put that
Yes, please.
into the present fact.
Here is Venkataramanappa who is saying I am the owner of the property. Venkataramanappa is not saying somebody else is the owner. Venkataramanappa is making erroneous statement that he is the owner of the property. Now that is completely covered by 43 because it is not only fraudulent, but not even if it is erroneous. But this is a principle of equity in section 43. A person who sells the property, the whole basis of 43 is equity. A person who sells the property and has taken money, and on the day of sale, if he has no title, but he acquires title subsequently, cannot say, my buyer will get more right. It is to prevent an inequitable situation of that kind that 43 has been. It is not a case of fraudulent fraud. There is, in fact, two terms are used in section 43, fraudulent or erroneous. Independent of all that, there is one other development that I want to point out to you. But there are subsequent sale deeds also that have been given by Venkataramanappa.
Correct.
So therefore, this question of feeding the grant by estoppel, what is the effect of the sale deed?
Sir, how far can we protect that person and how far can we protect your clients? See, having known that he himself had no right.
That's exactly what it is. I mean, if I buy a 43 does not require minuses. 43 does not say I should be a bona fide person. Let me assume that I overnight buy a property from a person who does not have title on the day on which the property is sold to me. But subsequently, if my vendor acquires title, that's exactly the situation covered by 43. Because if you, and especially where the vendor makes a representation to me that I am the owner, I blindly, without making any inquiry, let me assume I buy the property, pay in the consideration. Law considers, my lord, that to be an equitable circumstance to say that the vendor who on the day he sold the property did not have title, but he has subsequently acquired title, that should inure to the benefit of the purchaser. That is 43. This judgment does not deal with that situation at all.
This judgment is a case where the vendor was not saying this is my property, I am selling it to you. Vendor, the mother said, this is my child's property. Minor, I am selling it to you. The law says permission of the court is not obtained. That is a condition precedent for selling the property which is not selling. That's the distinction.
No. Yes. Heard reserve.
But actually, so what is entered there is a presumption that is the status of the land as well. It's filtered in state of the 1962, entire 88 acres is not in the name of the Inamda and not assessed with the that one more issue. During these proceedings before the Honorable Court, there was an order to vacate status quo. So far as the land that is rented in my number 21 acres, it is a vacant portion. I am taking for 40. The tribunal said only 21 acres to vacate, so I give only 21 acres. That cannot, if the lordship comes to the tribunal.
So, you're given a synopsis. You're given. You add one more page. This last submission that you made. You just add one more page to that and give it. Yes.
The submission you wrote. In serial number 45, my lordship, there is a interim order.
All other matters next week, sir.
Interim order is there, my lord.
Interim order will be extended.
Much obliged. Court officer. Court officer.
This is number 54.
Court officer. Serial number 45 interim order is sir.
This is number 54.
Court officer. Court officer. Off ಮಾಡ್ಬಿಟ್ಟ. Court officer. Court officer. Court officer. ಇಲ್ಲಿ ಆಫ್ ಮಾಡೋಣ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯೂಟ್ ಮಾಡೋಣ. ಕೋರ್ಟ್ ಆಫೀಸರ್